Yes. May I please, Your Lordship? I paid for listing to MSC in the first week of January, Your Lordship. 4th of January. Objection.
Check with the concern of the other side that you mentioned item number 48 of today's list. Come after that. Item 68.
Transfer petition. Okay. With consent of the other side, Mr. A. Ganguly, counsel for the petitioner, prays for adjournment. Prayer is allowed. List after ensuing winter vacation. Transfer petitions is, you just make a mention if it is not listed. Because of the fact that after every matter is being pushed after vacation.
Stay to point.
Oh, interim order passed release and extended till the next date of listing. Yes.
43.
Yes.
I'm the petitioner.
Yes.
Before your lordship, additional affidavit was filed by the respondent, which we have filed a reply. There is a not on record. Plus, we have taken their consent matter. They have to come after the case.
Okay. With consent of the other side, Mr. D. Mazumdar, senior counsel, assisted by Mr. A.S.K. Deori, counsel for the petitioner. The submits that affidavit in reply has been filed. That they said affidavit be tagged with the record. Moreover, next matter. Moreover, with consent of the other side, he also prays for adjournment. Prayer is allowed. List after ensuing winter vacation.
22nd. 22nd. That takes dates because they want to dispose of this.
Okay, 22nd January.
Interim order will continue.
Okay, interim order passed list and extended till the next date of listing.
May I please, my lord, item number 7, my lord. This matter may be taken after vacation, my lord. In the meantime, I will personally visit this spot, my lord.
Pardon me, I did not get it. Please repeat again.
Item number 7, my lord. It will be taken after vacation, my lord.
After vacation, okay. 7. On the prayer of Mr. A.H.M.R. Chaudhary, counsel for the petitioner, list after ensuing winter vacation.
Another prayer in respect of item number 25 and 26, my lord. These two matters will be taken before in December, my lord. These two matters will be taken during the
20?
last time.
20?
25 and 26, my lord.
25, 26. Oh, personal appearance. Okay.
This may be reflected in the display board, my lord, for information of other side.
Okay. You tell them you will get them, no?
It is very difficult in this case to inform him, my lord. That is right.
Why? Mr. A.K. Prakash is there. Okay. Will be taken up at chambers. This item 25 and 26. In chambers at 1 o'clock. At 1 o'clock.
1 o'clock. Obliged. May I please, your lordship?
Yes.
I'd like to mention item number 16, your lordship. Matter can be adjourned and taken up after vacation.
16. Okay, 23 matter. Okay, list after vacation is paid for by Mr. H. Buragoy, counsel for the appellant. 16 and
Only 6.
only 16. Okay.
Please, Lord.
Yes.
I'd like to mention item number 3. Can
Three.
we adjourn the matter for today?
Okay.
Yes. Item
List after ensuing winter vacation is paid for by Ms. M. N. Konyak, counsel for the petitioner.
Right.
My pleasure, lordship. I beg to mention item number 6, lordship. Kindly adjourn for the day, lordship.
6. Okay.
Vacation.
List after ensuing vacation is paid for by Mr.
A. Alim Eske, lordship.
A. Ali.
A. Alim Sheikh.
A. Alim Sheikh, counsel for the petitioner. Okay.
Very good, lordship. Lordship, I have filed the civil revision sanction yesterday, madam. So you're taken up tomorrow, madam. My adjournment has been rejected and an application in the guise of order 41 rule 27 and the case has been fixed for judgment. But the order 41 rule 27 application is generally considered at the time of hearing, lordship. But I have even no opportunity to do that, lordship, and it is directly fixed for judgment. My adjournment has been rejected, madam. So I filed the civil revision petition, lordship. But tomorrow, madam.
No, but what opportunity you want?
For reducing additional evidence.
No, no, that has to be considered at the time of the final orders only. That is the judgment of the Supreme Court. You see this, what do you call that, Mohammed Ibrahim. That says that that application will be considered only at the time of final judgment.
Exactly, Lordship. That is the reason why I have filed an adjournment petition to file an application under order 41 that has been rejected.
Oh, no, that can't be permitted. But you, okay, bring it. You see, to take an adjournment to file that application is withholding the court to pass a judgment.
That is with regard to the state of hearing, my lord.
Okay, let us see, let the matter come tomorrow. We'll see when it comes. Yes,
Sir, Lordship, I beg to mention for listing of a matter, Lordship, CRPIO, Lordship for tomorrow. The matter pertains to injunction matter, Lordship.
it's a new matter.
New matter.
What is the urgency?
Lordship, the mandate of order 34 rule 3 has not been followed, 3A has not been followed in this application. Lordship may be time for tomorrow.
Okay.
And your lordship.
It's a concern of other side, I beg to mention item number
Item number
33.
30. You're sure they have taken consent of all the sides. There are several lawyers.
Yes, Lordship. We are for, I am for the respondent number 1. We took the consent. Yes, sir.
What about other counsel?
State also.
Okay, with also there, sorry, the counsel for applicant, respondent numbers 1 and 2, and respondent numbers
4 and 6, state.
2, 3, 4, and 6.
Yes, sir.
Representing the state are present on the prayer made by Mr.
C. Talukdar.
C. Talukdar. Counsel for
Appellant.
for the appellant. Matter stands adjourned today. Let's stop answering vacation. Winter vacation. Huh.
Deeply outside.
Your Lordship, I beg to mention item number 4, with the consent of the other side, I beg to mention, number 4, kindly adjourn the matter for the day.
Okay, you're taking consent? Okay, with consent of the other side, Miss
Embora.
Ambora, counsel for the
For the petition.
petitioner prays for adjournment. Prayer is allowed. List after ensuing winter vacation.
Sublet.
Okay.
Daily list item 1.
Yes.
When the wife of the
What is the reason?
recent process I take from Bangladesh, and my husband filed divorce case at Silchar. It is very much inconvenient for me to go there. I am unemployed women lordships.
Okay.
And
No.
proceeding-
Okay, okay. Miss R.B. Bora, learned counsel for the petitioner, transfer matter. Notice test within 2 days. As an invitation till the next return of the day, proceedings of so state, subject to condition that the petitioner shall produce a certified copy of the order before the learned trial court to bring the order to the notice of the said learned court.
One order, the next person, one part of the order. Now, lordship case is, ex parte arguments this lordship, kindly stay the proceeding.
I've stayed it. Oh, stay application is separate. Okay. Then notice on that also.
Main আৰু এই দুইটাতে notice হ'ল
Notice on.
after কিমান
Did you 4 weeks or 6 weeks? Did you notice of somewhere? Item 2.
item 2
It's a ejectment suit.
My lord, this suit is for engineering.
This non-appearance and call for the petitioner. The petitioner, this civil dividend application. However, Mr. G. Bushel and counsel for the respondents, only sole respondent. Sorry, respondents is present. Full stop. As
This one number two.
the court finds that the revision petition as well as the documents appended thereto. No, sorry, revision petition contains highlighted portion, comma, the same is not found to be in consonance with the Guwahati High Court rules, and therefore this revision petition stands returned with liberty to the petitioner to approach again by rectifying the unwanted highlighting.
Item 5.
Yes, 5. Non-appearance on call for the petitioner. This is the second date when the petitioner is absent on call. For ends of justice, the matter stands adjourned today, list after ensuing vacation, winter vacation.
Item 8.
It is Lordship, the present contempt case is filed.
Just a moment. Yes,
It is ordered, it is, Your Honor, 21 to,
where is that order?
the injunction order.
Where is that order?
At page number 52, Your Lordship.
52.
Waiting portion, Your Lordship, your page number 56, Your Lordship. Paragraph number 15, Your Lordship. Whereby the appellants are restrained from constructing, Your Lordship.
Okay. Hello, Mr.
And Kashyap, Your Lordship.
I am Kashyap, done counsel for the petitioner. Willful disobedience of order dated 21/3/2023 passed by this court in IA Civil 382 of 2023 is alleged in this contempt petition filed under section 11 and 12 of the Contempt of Courts Act and with Article 215 of the Constitution of India. Issue notice returnable on so and so. The petition shall take steps within 2 days for service of notice on the respondent. So sorry, opposite party. Returnable on so and so. Sorry, steps in 2 days for service of notice on respondent for opposite parties. Next, by the opposite party is also put to notice that any further construction carried out on and from the date of service of notice of this application. Shall be viewed very sternly, and therefore the opposite party, namely Ashraful Alam, is once again prohibited from carrying out any construction whatsoever in violation of the order dated 21/2/2023 passed by this court in IS Civil 382 of 2023. Just say one more thing. Notice the petitioner is the petitioner is also permitted to take steps for service of notice on the opposite party by usual process to be routed through the civil nazir of attached to the establishment of the learned district judge. The office of the learned district judge, Kamrun Metro, Guwahati. List on so and so.
7.
Take steps both ways. 54,
After item 54.
yes. It's 5,500
Plus 500.
plus 500 litigation cost. We are issuing a notice. In the meantime, we are not staying it. Although I'm disinclined.
As per Rajneesh, it is a mandatory requirement that
Oh, we have told you on that day. This,
But recently Supreme Court has issued another directional judgment on 7/11 year lordship, saying that this resolution is not followed, for which a large number of litigations, the judges have to decide on the basis of preponderance of both sides. So again, a direction has been issued. I have the soft copy lordship, and just pass.
no, just tell me
The lordship,
the.
it is decided on, again, direction is issued. The party's name is Jitesh Sharma, but
Just a moment.
criminal appeal number,
Just a moment.
the court remanded that first you.
Hitesh.
Party's name, criminal appeal number,
No, no. What is the name of the parties?
Aditi, ADITI,
ADITI.
alias Mithi,
Aditi versus Mithi versus this Hitesh Sharma.
Jitesh,
Yes.
is decided on. The court has noticed that a large number of proceedings, this mandatory requirement is not being complied, for which a large number of litigations are coming up regarding the amount, and therefore, again, a direction has been issued, your lordship. Paragraph 14. That both the parties file assets and liabilities, and then the matter will decided there, your lordship. It is my limited prayer.
Mr. M.H. Laskar, counsel for the petitioner. The order granting, order passed by the, order dated 7/10/2023, passed by the Learned Additional District Judge Jorhat in TS within bracket M 32 of 2023, thereby granting maintenance. Pending light maintenance and cost of litigation has been challenged by the petitioner by filing this application under Article 227 of the Constitution of India. This 115, you please, you'll have to remove it. Otherwise, we'll have to dismiss this application. Any topic, right? On the prayer made by Learned counsel for the petitioner is permitted to strike off the provision of section 115 from the cost title of this application, and therefore this application is treated as one under Article 227 of the Constitution of India. Then that issue notice returnable on so and so, states within 2 days. Posted this track report till notice and including notice on the prayer for interim relief. As per be mentioned that the challenge is based on the fact that in the trial proceedings, the parties had not filed an affidavit to bring on record the income and assets of the assets of the parties on record, which according to the Learned Counsel for the petitioner is the mandate of the Supreme Court of India in the case of Rajneesh, RAJNESH versus Neha. Within bracket 2021, bracket close to SCC 324, as well as Aditi ADITI, alias Mithi MITHI versus Jitesh JITESH Sharma SHARMN. Within bracket 2023, bracket close 0 Supreme, within bracket SC, bracket close 1111. Thereafter, issue notice, including notice on the prayer for interim relief. Take steps within 2 days. The next, the last, before that last date, list on so and so, right? The order of maintenance shall be subject to further orders that may be passed by this court.
Apply.
55 supply.
Your lordship, I kindly pass over the matter for the time being.
Time being,
Yes.
okay.
9 for admission.
9.
Hold on a simple decision. So filing decision under order 22.
Just a moment.
There is a delay of 692.
In substitution, there was a delay. Hmm?
For filing substitution petition.
Yes, what is your objection?
If filed by objection or if in IA 297.
Yes, what is the ground of objection?
Okay, first of all, they have not filed any document showing that the respondent 6 is expired.
Are you denying that he has expired?
If, I have no knowledge actually, but they have want to substitute some person. And also the person wants to substitute, her name is different state lordship. Once her name is mentioned that Dia Burman and another place Dia Burman. So there is also no document that sees the legal year of the respondent was 6. When the letter here in the context is.
You are appearing for?
I am appearing for respondent number 1, 2, 3, 4 and 7.
1,
1,
2, 3,
4 and 7.
4 and 7. Who has died?
6 expired.
6 has expired.
5 is expired.
5. Five or 6? Who has expired?
Is the daughter of
No. Who has expired? You say 6, he says 5. 6. 6, right. Then we allow it. If you don't know about your sibling, it is very unfortunate. We can only say that. We allow it. Because being our correspondents and siblings, it was your duty to inform the court that somebody has expired. That was not done. So delay is condoned.
They have carried, but if, what they have stated in the petition that they want to know about this substituted respondent lordship from the Facebook, from the not legal lordship, from Facebook, they want to know that this is the person of.
But you can't object. The difficulty is you can't object and we can't hear our objection. It is for the legal head to come and say that my Facebook posting is wrong. How can you object?
They can put it that person lordship. And file.
Yes, we'll issue warrant of arrest, arrest him, bring him here. Don't say all these things. You are a seasoned lawyer. Don't say these things. He will produce. How will he produce? It is just like Lord Hanuman. He will just carry this man, what you call, along with his house and bring him here and show it to the court that, look, this is the man. This is absolutely rubbish. He will bring the man. It's not unexpected from a learned counsel that he will bring a man. How in a adversarial proceeding one will bring a man? Then we don't need the process server at all in the entire state. We'll just ask the petitioner, you have filed a case, bring that man. Is it not something very absurd? And I'm not accustomed to hear all this rubbish. Heard. Mr. R.K. Jain done counsel for the applicant. As well as Mr. R. Sharma, P. Sharma, learned counsel appearing for respondent numbers
1, 2, 3, 4 and 7.
1, 2, 3, 4 and 7. Next for the as basic facts of both these interlocutory applications are common. and similar, comma, both these applications being application for substitution with application for setting aside abatement as well as for condonation of delay are taken up together. It is projected in this application that the applicants who are the petitioners in the connected CRPIO 295 of 2017 had come to know about the death of respondent number 6 only on 17/12/2020 when one Priti Dekha Boro, Prity Dekha Boro, introduced herself as daughter of the deceased in a social media within bracket Facebook bracket close posting. Post of. Accordingly, the necessary information was collected and this application has been filed, and in the process there was a delay of 692 days from the 782 days of delay from date of death of the respondent number 6, which is stated to be 10/10/2018. This notice was not issued.
No, notice was not issued. There is objection regarding communication.
Oh, then there's nothing. Post accordingly, they issued notice on the issued notice on the opposite parties, including opposite parties numbers.
No, these parties are before you.
No, the substituted parties are not there.
Only single.
Hmm?
Only one.
So I'll have to say that because I'll have to dispense with notice. I'll have to issue notice on them also. Okay, including notice on the opposite party number 6 who is sought to be substituted. Full stop. As opposite parties number 1,
1, 2, 3,
2, 3,
4 and 7.
4 and 7 are already represented. And they have filed their objection, no fresh steps is required to be taken on them. So the petitioner shall take, applicant shall take steps within 2 days for service of notice on the opposite party number 5 and 6.
The 5 will also expired. 5 also expired.
5 also expired.
But she was considered, so other legal
Oh, okay.
are already on record.
On respondent number 6, by registered post with AD. Notice is made returnable on so-and-so list accordingly. Before that, you write, the learned counsel for the applicant submits that the respondent number, opposite party number 5 was unmarried and she has expired and they are leaving no other legal representative. And accordingly, he pays that the name of the opposite party number 5, who is the respondent number 5 in the connected CRPIO 295 of 2017 be struck off. So the said oral prayer is allowed and the name of the opposite party number 5 as well as the name of respondent number 5 in the connected revision stands struck off. The official carry out the necessary correction in the cost title of CRPIO 296 of 2021 and 297 of 2021, as well as the cost title of CRPIO 295 of 2017. List on so and so, awaiting service of notice. In CRPO, right, in view of order passed today in so and so, name of respondent number 5 is ordered to be struck off. Both notice will go in both dated, huh?
You said
Two.
7-2.
7-2. Item 10,
Request for stipend. There is dismissal of my counterclaim.
against counterclaim. Okay, heard Mr. S.D. Purkasthar and counsel for the appellant. Is regular first appeal under section 96. CPC is referred against judgment and decree dated 25/7/2023, passed by the Learned Civil Judge within bracket Senior Division, bracket close number 2, Kachar Silchar in TS 94 of 2018. First one, comma by which the counterclaim of the appellant respondent, appellant defendant was dismissed. Appeal is admitted for hearing, call for the records. Notice steps within 2 days, returnable on 7-2.
Item 11. 11.
Yes,
Lordship, it is input order, the Lordship will find page 199. Against which is, she has been referred.
just a moment,
Is it that, my lord?
just a moment. Yes. Yes,
Page 199, page 200 is the 11%. Otherwise, my lord, petitioner is the defendant number 3. And in the court, there is the status quo order.
yes,
And against that, my lord, petitioner filed an application under 151 CPC, praying that regarding his house and other residential premises, there is some damage. And that was allowed by the trial court for repairing. That is your lordship will find. And thereafter, my lord, while he was starting repairing, the plaintiff obstructed him and he filed an application before the police. They did not provide any help. And against that, he filed an application for and directing the police to or providing police protection for repairing of the house. That was rejected.
where is this order dated 18/7/22, which page?
That is my lord, your school file. 169, page 169. Seventy is the relevant person. Seventy-three, my lord, last para, you will find.
You are the plaintiff or the defendant?
Defendant. Defendant number 3. Page 175, accordingly, the sought for prayer for grant leave to repair the damages of the petitioners allowed. However, it is clarified that the protection provided by this order shall be applicable only if the petitioner adheres to other specific conditions as ordered by so-and-so, 6/8/18, measure number so-and-so. To be more specific, if no such house was present on the date of passing of the injunction order, the petitioner will not get any protection under the guises of the order. Further, the petitioner shall refrain from erecting, making any.
Where is this
permanent
order of 6/8/2018?
First,
6/8/2018, where is that order?
2018, lost to find at page. Yes, lost, we will find, 28. Order is not there, on the civil fine, page 152, 28/6/22, that is the order, my lord, of
152.
152. Six, eight, 18 order is my lord, 118, page 118,
118.
118, 6, 8, 18. And we 27, 2018. One on 9, lawsuit fine, last para.
I have read it.
The status code. Only.
Just
Yeah,
a
that
moment,
my lord.
just a moment. And where is the order passed in this review petition?
By petition.
No, review petition, what is the order passed? Review was filed. Mejia case 106. What is the order? Mejia case number 106?
Case number 106, that is.
Page 178. What is the order after that?
Application, that order is not there.
It's not there.
Not
Okay.
Thereafter, my lord, order is 26/9.
Then what had happened? You filed for enforcement.
Yes, ma'am, I filed for enforcement application and by the order dated lordship 1/10/22, that was rejected on the ground that it is a matter of criminal, matter of police, so civil court has no jurisdiction. Finding is that my lordship will find. Page 202.
Can you get the, what do you call, but this has not been counsel for the petitioner. By this application under Article 227 of the Constitution of India, comma, the petitioner has assailed the order dated 1/10/2022, passed by the learned Munsif number 1, Dharan Mangalday. Acha, this is 22 order. What has happened in the meantime to the review petition?
22 months. 22.
No, that review petition, their notice was issued 106. What has happened there?
That inspection. Yes.
No, you see, that will be relevant because without that, we are not passing any order. The reason is that the trial court in the impugn order has said that the in the review petition against the order of repair, a notice was issued, and the court expressed its doubt as to the correctness because the circle officer has given a report that there was no flood in that region. And therefore, the veracity of your contention that the house has been damaged by flood was doubted by the trial court. So that is the order of what you call October 2022. Something must have occurred in between, because now we are in the end of 23. You have to get the what you call order passed. You can get a downloaded copy of the order from the website and present to us. We'll take it up at 2 o'clock if you can show us.
Next, after vacation, I take my.
After vacation. Okay, because now we have everything in website. You can produce the printout from the website and show it to us if you want an order today.
When the order is passed, then available. If not passed, then it will. be
Okay.
possible so much.
It appears from the impugn order that in connection with review petition, which was numbered at MISJ case number 106 of 2022, the learned trial court had issued a notice. And moreover, in the impugn order, a doubt was expressed to the to the stand of the petitioner, which is based on certificate issued by the revenue circle officer indicating that no flood had occurred in the concerned village during this said year. Therefore, the court is of the considered opinion that the present status of the said MISG case number 106 of 2022, as well as the order sheet thereof be produced before this court. So as to ascertain as to whether whether the operation of the order dated 18/7/2022 passed by the Illinois Trial Court in MISG case number 85 of 2022 has been interfered with. Next, Illinois counsel for the petitioner seeks some time to produce information in the order sheet. So according to matters adjourned today, list after ensuing with the vacation. You make a mention if it is not listed. Because you're not fixing a fixed date now.
সেইটো ৰাতিপুৱা এডজনমেন্টৰ কাৰণে মেনশ্যন হৈছিলে, এতিয়া এগৰাকী অভিযোগতে আহিছে, তেওঁ কিবা এটা কয় বুলিছে, মুন্না গুচি যাবতো চাগে।
Okay. Yes. What has happened in item 3?
কন্যা item 3.
Oh, acha. The petitioner has made a mention. You are appearing for whom? For your side, somebody made a mention. Yes, the on record, Mr. M. Konyak is there.
Other side, applicant side, we have 5 applicants, from our side, I am only the applicant.
No, on record, Ms. Konyak is there. He has made a mention.
How can it?
No, that you don't, that you know, you find out.
From other side.
No, I don't know which case you are appearing. Your item is which item?
It's Srimati Niva Talukdar and others.
No, something else. Item 3 is Pinky Borai. Please check out. Your item may be a different item. Please check up. Item 12.
Order. Passing injunction application.
Just a moment. Yes.
The injunction order is at page 139. Annexure I.
$39.
Annexure I. Started
39 or
39, but relevant it started from 140.
oh, 140. Okay.
Whereby the learned court below restrain the plaintiff, appellant's plaintiffs from entering into the suitland, the appellant's plaintiff who filed the suit and directed to keep the suitland in lock and key, under lock and key.
What is the suit? Let me see the plaint first. Where is the plaint?
Plaintiff, that's page 26, annexure A.
Okay. Where is the injunction application?
Page 85.
65. No, 65 is something else.
85.
85. Okay.
Connected.
Okay. So trial court granted you injunction.
High Court initially on 3/4/2023 passed ex parte injunction. However, at the finally, the injunction application was disposed of.
Where is that order?
That page, which one order is it?
The disposal order?
That page 140. The impugn order,
148,
140.
140.
For the portion at page 140. Therefore, in the interest of justice, Your Honor, kindly on page 141,
Just a moment. Where is the order of the settlement of land in favor of the respondent? Where is that? You have it? The government will have it? No. The BTC will have it.
I have to get the instruction. There will be a.
Hmm?
There has to be.
No, because you see, you come to this order, it doesn't show that there is an order. This impugn order at page 140 onwards, it doesn't show the existence of an order. If you can demonstrate from the written statement or written objection that there is an order, Can you show from the objection? Where is the objection to this injunction application? Objection to the injunction application is where? Which page?
State respondent is at page 122. Annexure G. Not at 120.
Just one minute. No. Then I think your suit is misplaced. Is a, the relief can't be granted to you. You see, so far as I have understood, when I read alone, I do, without any assistance, I don't know whether I've read it right or wrong. You see, your case is that the government allotted a land to NDAB, surrendered NDAB. And this, you applied for mutation in the name of the precedent. Correct? Correct, yes, yes, it is there. Hear me. You applied for mutation in the name of the precedent. After mutation was done, the president transferred the land to his wife. And thereafter, this wife came into league with this opposite parties. And they are now trying to have it. And that is one part. Your suit is only for confirmation of possession. And you will not be granted an injunction unless you have a title. Your title you have lost. You come to page 65. Because the matter is voluminous, I won't remember the pages, so it took me some time to recollect my memory. Page 65. You see, third or fourth paragraph. Again, it is also seen that Janendra Basumatari, son of so-and-so, transferred the land in question through registered sale deed number so-and-so after getting permission from the BTC. And thereafter, land was mutated. After that, the land was sold to his wife.
But here in this case, the land was allotted to NDFB.
That we don't know.
And the mutation was also granted in the name of NDFB.
I know that, but it's cancelled. You see, the mutation was in the name of so-and-so. So unless you have this.
The president fraudulently.
No. You see, whether it was fraud or not, it is not for this appellate court to look into it when I am looking at the FAO against the order of injunction. Your suit is simpliciter suit for confirmation of possession. And on basis of that, you are not getting an injunction because of the fact that the lawful title is transferred to somebody else, and therefore, by way of an injunction, you cannot be permitted to enter into land of a third party. As simple as that.
At present, this is
That we don't, I have shown it to you, and this is an order of the by the circle officer.
But your lordship may kindly see the.
Now, I've seen that, otherwise I would not have made that statement.
Page 69.
69.
The order whereby the respondent number 2 directed for partition.
You see, whatever happens thereafter.
Against that order,
No, partition, you see, it doesn't take us anywhere. Number one, I am not deciding on title. Therefore, I will not go into enter into the dispute who has the title, where, how the partition took place, what is the correctness of the order passed by the Land Revenue Department and Borderland Secretariat. That we don't know. That means this is a classic example of something which we have seen in when I was a young lawyer, guided by Mr. Sendeka here. You see what happened there, when we appeared in 144 proceedings or 145 proceedings, the magistrate would write in the morning, 10:30, heard so-and-so, I am satisfied that there is a breach of peace, and the orders were passed. And at 3:30, when you go to collect the copy, then you find that the same magistrate is writing, the other side has appeared, I am satisfied that there is no breach of peace and therefore order is vacated. We have seen those days. This is a classic example of that. You take a call, we'll take it up at 2 o'clock. In the meantime, you take a call, what to do? Because this is, if the title, you see, once the authority says that the title has been validly transferred by way of a sale deed, then by way of an injunction, this could be very, very slow. Or using the word, legal terminology being used, the court shall be a loath to.
By the impugn order, the Suitland directed to Suitland we keep under lock and key and directed the appellant and respondent from entering the Suitland.
No, so far as your disallowance, we find there is no infirmity. That's why I'm saying you take a call. You take a call, you think over, come back at 2 o'clock. Because I'm prima facie not satisfied because of that only. After vacation, okay. Mr. A. Chaudhary, counsel for the appellant, and Mr. S. Bora, standing counsel for the BTC, and Mr. S. Datta, standing counsel for the Revenue Department, and Mr. T. R. Gogoi, learned government advocate, are present. Government advocate for respondent 3 are present. On the prayer made by learned counsel for the appellants, list after ensuing vacation. If it is not listed, you make a mention.
I love it.
13. Just a moment. You are against the allowing of amendment.
That type of argument is over. We have submitted an argument, defendant. They took time. Subsequently, after 2 days, they have filed amendment. Because in the year 2011, initially they claimed for declaration of title and injunction and cancellation of DP. Thereafter, they filed 2 injunction violation petition. And injunction violation was rejected. And
But if you see if the respondents are evicted without due process of law, despite the delay, they are entitled to amend it.
they have concealment of fact. Initially, they have filed for declaration only, not confirmation of position, not recovery of position.
Okay.
Subsequently, they falsely filed a petition in 2015. Initially, the injunction was granted on 27/1/12.
Thereafter, in 27 to 15, they have filed an injunction violation of petition. That we enter and violated the court order. That was rejected because it is actually not correct. A false statement. Then, my lord, there another, again, they filed another petition. Thereafter, they filed an amendment petition in 2013.
Where is that?
Page 59.
Page 59.
59.
Yes.
That petition was allowed, my lord. Amendment was allowed, my lord. The situation is remain same, my lord. In that petition, they have not prayed for amendment, my lord. This particular amendment petition, they have not agitated that petition. Then, my lord, again, they have filed another injunction violation case, my lord, India 2019, my lord. That was also rejected. Again, another petition, my lord, injunction violation, that was rejected.
No, you see this, this injunction, or amendment application.
Yes.
It is only in respect of his illegal disposition from E-scheduled land.
E-scheduled land particular on that amendment petition, my lord. And the disposition by me is prior to that, man. We have prior to that, as per their version, because our version is that we have right from 1996, date of purchase, we are possessing the land by constructing the house, and we are residing the agreement. They have concealed that fact, Miller. Subsequently, they have filed violation, Miller. That was rejected because factual.
Shows that.
That, Miller, page 56, first injunction petition, Miller,
56.
56.
This is,
That is, 56 is the
violation order.
violation.
Yes. Just a moment, you are making me drink water. Yes.
So here is the relevant point, my lord. They are cutting of the art, etc.
Hmm?
Cutting of the art, etc. The LS violation, my lord. But in that time also, my building is there, my lord. Evidence is there. They have it is evidence, my lord. And subsequently, my lord, they filed another petition, my lord, in 2019. Page 68.
Page
68. That petition, at the time of filing that petition, they did not disclose me the earlier petition. It is reflected in the order. He has admitted, my lord, the plaintiff has admitted. That order itself reflected. He further stated that the opposite party has been staying in this land since 2012.
Yes.
Therefore, the opposite party did not adduce any evidence. The evidence on the record do not inspire confidence and do not sufficient to come to the conclusion that the opposite party has violated the status quo order. It is also found that the petitioner plaintiff has not disclosed at the time of filing of the petition number so and so, case number which is only revealed that the time of precedent one. Again, the effort of the petitioner in the present case is found to be not sufficient for any reasonable man to come to the conclusion that the status quo order dated 27/1/2012 in connection with this case number so and so has been violated. Therefore, the present this case is dismissed from contest without cause as the photograph given in the exhibit as well as the other exhibit do not have the case of the petitioner. After another petition, my lord, here is in case Miller 73.
You have a copy of that photograph? Which is a part of this? No. Yes.
So, my lord, thereafter another petition was filed by Ms. J case number 22314, page number 74.
'73. Order in, order dated 28/1/19.
Their order also same date. It's also same date. There was a similar order passed, madam. But regarding the moreover case 74, madam, moreover perishable case report reveals that Amin Commission report which was filed by the for perusal of the case record reveals that Amin Commissioner
You're reading where?
case 74, madam.
Huh.
Moreover, perusal of the case record reveals that Amin Commission report which was filed by the Amin Commission after survey of the land was also not brought on record in the form of evidence by the petitioner, which shows that the petitioner is not serious in this support. Therefore, the present music is now is dismissed on contest without cause and paragraph given in every concept. So they are trying to change the nature of the nature and character of the issue by way of initially they tried 3 or 4 petition my lord by way of amendment by way of injunctive violation. After they failed me, evidence was additional. We have it is 15 witnesses and they have 7 witnesses. We have it is 15 and they have 7. And all prosecutions are overwhelmed. Thereafter, therefore, argument 6 million. They initially one day we took time. Thereafter, they took time. We filed our we argued the case. They abstained. They did not argue. Took time and subsequently, when their turn came, my lord, they filed this petition. So, my lord, the basic principle. The order 6.
Where is the amendment application?
78.
Plus 78 million. My lord, in in page 80, their petition, para 9B, proposed amendment, my lord, that the pendency, have the pendency of the title suit number 26311. The defendant number 3, Durbal বিশ্বাস, please. Nine B, I am reading 9B, their proposed amendment. Illegally disposed the plaintiff from a part of DCD land and.
Page, page,
Page number 80. Page 80. Para 9B.
yes,
That at the pendency, that at the pendency of title suit number 263 2011, the defendant number 3, Durbal বিশ্বাস, illegally disposed the plaintiff from a part of DCD land and erected his dwelling house on 29/11/12 and 30/11/2012, and for that plaintiff filed a miscase number in. So my lord, 2012, I have constructed illegally as per his version, although I am possessing long back. Even if it is admitted, my lord, 2012, there is a file, I have erected. So how, my lord, after so long period, my lord, and even after the argument, evidence, everything is over, my lord, how can make amendment, my lord? It is, otherwise, what happened, my lord, all the evidence will go, my lord, because we will have to file again, my lord, additional written statement. We have to edit the evidence, they will have to edit the evidence. Like a retrial. It is admitted that at least from 12, this situation is, yeah. They filed petition in 2023. One thing is that, my lord, the Karnataka trial court in deciding the violation petition, my lord, he observed at page 57. Their petition is not bona fide, and their consignment of fact, different stage of the cases.
okay. Yes, Mr. Kalita. You're relying on any case laws? You're relying on case law?
Yes, law relied by the trial court, my lord, in allowing the petition, my lord. That is, my lord, life insurance corporation. Supreme Court of India, my lord. My lord, Air citation is there, my lord. CC citation is there, air Supreme Court 4256, my lord. In this case, my lord, Honorable Apex Court said that the amendment should be liberally granted, my lord, should be liberal. But there is condition is there, my lord. In condition, my lord, in paragraph 17. Several condition is there. In some condition, in our government. So that ruling is in our favor, in fact.
You mark that portion and give it to us.
Yes.
Copy.
I'm reading that, I'm marking that.
Yes.
By the amendment, the party seeking amendment does not seek to withdraw any clear admission made by the party which confer a right on the other side. This is one matter. Then their amendment does not raise a time-barred claim, resulting in divesting of the other side of a valuable accrued right. Then, my lord, by the amendment, the time-barred claim is sought to be introduced, in which case the fact that the claim would be time-barred become a relevant factor for consideration. Thereafter, my lord, my lord, there is subsequent to that, my lord, there is another judgment, my lord. By Tuesday, just bench, my lord. In that case also, the justice JB Padiwala was in this case also. Both the case JB Padiwala is there. In this case, also, my lord, the conditions are there. There should be liberal approach, but my lord, there's certain conditions are there.
Just mark those paragraphs. Yes.
The injunction petition clearly stated that why this injunction petition was there. Now the trial court will consider whether it is a belated one or there is due diligence or not. The learned trial court in its judgment clearly covered all these things, my lord. Your lordship may be pleased to see the order, impugn order at page 92, matter. 92, first portion, my lord, clearly stated what amendment was asked for and what is the objection, my lord. At page 95, we can come, my lord. OP have filed 18 objection, last portion, my lord, 93, 95, my lord, last portion. Stating that the petition and affidavit of the plaintiff are not maintainable, both in law, in fact, and the petitioners have not come with clean hand and suppress the real fact. The petition is brought at belated stage of the suit, which is liable to be rejected. They have contended that the petitioner instituted a suit in the year 2011. Accordingly, the defendants submitted their written statement. Thereafter, the plaintiff brought a petition under Order 6, Rule 17, bearing so and so, filed on 31/5/2013, but did not disclose the facts narrated in the instant petition. The allegation of erection and disposition mentioned in the instant petition, dated so and so, which is found to be prior to filing of Misday case number 125/13, wherein it is clear that the plaintiff mentions all dates in the instant petition. The defendant number 3, Durlabh Vishwas, purchased the land and got possession therein in the year 1996, and wherein he constructed a dwelling house and stated to live in his land since 1996 till date. The defendant number 9, Dhananjay Burman, purchased his land and got possession therein in the year 2008. The defendant number 9 constructed the dwelling house in 2008. The defendant number 6, Bimal Roy, purchased the land and got possession there in 2003 and constructed his dwelling house in 2003 in his land. The plaintiff, having knowledge of the said deed and possession of the defendant number 3, 6, and 9, made false allegation of dispossession. Earlier, the plaintiff filed petition under Order 39, Rule 2A against Durbal Biswas, Bimal Roy, Dhiren Karmakar bearing so and so, which is rejected with full trial after White Order dated 2015. Thereafter, the plaintiff again filed petition under Order 39 Rule 2A CPC against the said Bimal Roy, bearing number so and so, wherein the said Bimal Roy appeared and filed his written objection. After full trial, the miscase number so and so was also dismissed. The plaintiff also filed Mirza case number 222/13 against Dhananjay Burman, which was also dismissed. After full trial, the plaintiff also filed Mirza case number 515, which was also dismissed. In the instance suit, after filing of the written statement by the defendant, the issues were duly framed. Thereafter, the plaintiff side adduced their evidence in the year 2017 and did not take any steps to bring the instant fact in their pleadings. After prosecution of the entire plaintiff witnesses, the defendant side adduced their evidence. After completion of the evidence, the defendant side placed their arguments, but the plaintiff side avoided to place their argument. After hearing the arguments of the defendants, the plaintiff brought the instant petition at belated stage. In the instant case, not only the trial commences, but the trial was completed as per provision of law. The plaintiff should have filed petition before commencement of the trial. Once issues were framed, the case was ready for the reporting of the evidence. Then, on the next para 7, in the instant petition, will change the nature and character of disease, what my learned friend has stated, my lord. Now, next page, my lord. The second page. Now, looking into the amendment sought to be brought by the petitioner, it is seen that they are about alleged disposition during the course of the proceedings and for the relief of the recovery of possession amongst others. It is agreed that the amendment petition is being brought about at a belated stage, and to help his case, counsel of petitioner has cited numerous judgments, the crux of which was that petition should be allowed as procedure as a handmaid for the justice and should not be an impediment when seeking justice. Whether or not the petitioners have disposed, and if they were, whether they will be entitled to recover possession will be the lookout of the court at the time of deciding the case. But it cannot be ignored that the amendments sought for are necessary. The Supreme Court recently in Life Insurance Corporation of India 22 Supreme Court, my lord. This is the same principle adopted since 2005, my lord. All amendments are to be allowed, which are necessary for determining the real questions of controversy, provided it does not cause injustice and prejudice to the other side. This is mandatory. It is apparent from the use of the word shall in the latter part of Order 6, Rule 17 of the CPC. The prayer for amendment is to be allowed. If the amendment is required for effective and proper adjudication of the controversy between the parties and to avoid multiplicity of proceedings, provided the amendment does not result in injustice to the other side. By the amendment, the party seeking amendment does not seek to withdraw any clear admission made by the party which confers a right on the other side. Then the amendment does not raise a time-barred claim, resulting in divesting of the other sides of a valuable accrued right. A prayer for amendment is generally required to be allowed unless the amendments a time-barred claim is sought to be introduced. Then if amendment changes the nature of the suit, then prayer of the amendment is mala fide. By the amendment or other side loses a valid defense. In dealing with a prayer for amendment of pleadings, the court should avoid a hyper-technical approach and is ordinarily required to be liberally, especially where the opposite party can be compensated by cost, where the amendment should enable the court to pinpointedly consider the dispute and would aid in rendering a more satisfactory decision. The prayer for amendment should be allowed. Where the amendment merely sought to introduce an additional or new approach without introducing a time-barred cause of action, the amendment is liable to be allowed even after expiry of limitation. Amendment may be justifiably allowed where it is intended to rectify the absence of materials particular in the plain. Then delay in applying the for amendment alone is not a ground to disallow the prayer. Then, my lord, other things were also considered by the Supreme Court, my lord. Then another case was discussed, my lord, in last page number 102 last. In general, Ganesh Prasad versus Rajeshwar Prasad and others, 2023 FCC online. SC 256, it was again reiterated that the plaintiffs and defendants are entitled to amend the plain written statement or file an additional written statement. It is, however, subject to an exception that by the proposed amendment and opposite parties should not be subject to injustice and that any admission made in favor of the other party, etc. Therefore, though the amendments are brought at a later stage, but they do not alter or change the structure of the original suit. As well as the purported events had taken place after the suit was instituted and are necessary to adjudicate the matter and to ensure justice to the parties. I am of the opinion that only the delay should not be ground to disallow the petition. So, my lord, the Honorable Apex Court is very clear. And apart from that, my lord, our High Court, when Justice, it was not reported actually, Justice Amitabh Roy was there. That on in a particular case, when the argument was heard, thereafter also amendment was allowed. And that in that case, my lord, I appeared and schedule was allowed to be corrected. In that case, my lord, that was not reported, my lord. Now the
No, schedules, there are reported cases. Even I have authored orders in that effect. Because if the principles of Order 7 Rule 3, that the Supreme Court has said that it permits the correction of the boundaries. But you know what has happened after that decision of the Supreme Court and followed by us? I'll tell you, there is a pattern. There are two districts where this pattern is being followed. That's why after that we became wiser. In these two districts, what is happening? That one is your district. There, what happens is that a suit is filed showing say dag number 1 or pata number 1. Then boundaries are given and suit is filed, parties don't appear, the defendants don't appear, because that is not their land. Their land is pata number 2, dag number 2, and boundaries are different. So they don't appear. So at the fag end of the, after issues are framed and this ex parte hearing is ordered, then what they do is that they file an innocuous application saying that please allow me to change the dag number and pata number and the boundaries. And if unwittingly we do it, then the order goes against the defendants, because for that amendment also, the party is required to be heard. We tend to forget that, and since the case is going ex parte, because you see, if somebody files a case against you, saying that land at near the High Court, you will not be bothered to appear. And then they conspicuously say, no, not this. The land is Kumarpara. And they enter into your land. So that is happening in two districts. And we have seen a pattern in these applications being coming.
Now, sir, there are different cases, my lord, where the Supreme Court says, my lord, that the boundary will prevail. Tag number, pata number may be different. And at that particular case, my lord.
That's why I'm saying, I'm giving you a pattern. And this is not one case, I have handled more than one, and therefore I have seen this pattern in two districts. One is your district, that this litigating district here.
So, in this particular case, my lord, this is the latest Supreme Court decision, my lord. And Supreme Court has not differed from the earlier decisions, my lord. All decisions were subject to injustice because they will get the chance for filing written statement against the amendment of the plaint, my lord. And the evidence will remain, earlier evidence, my lord. That will not go. They may add fresh evidence against that also. If they get injustice, only injustice will be done, my lord, if they do not get any chance. Here in this case, that was not it. And Supreme Court in different cases, my lord, stated that they should be suitably compensated, my lord. Here, my lord, 5,000 cost is given.
Suitable.
And it appears, my lord, 5,000 today, my lord, in today's value, it may not be, but the court will not get more than that, my lord, trial court. The High Court has the now 20,000, 50,000 is given, my lord, that is different thing. But here, they were.
No, you are way back, what you call. Now you are quoting fees which I can't even count. I'm not referring to others, I'm referring to you. Huh?
More extra.
And then we can always, to add those zeros, we can also add this dot after the rupees, and then again two more zeros.
Yes, sir, my lord, in my opinion, zero has no value in the backside, my lord. Nowadays,
No value.
there's no value. Because every day, my lord, the prices are increasing. If I purchase one medicine today at ₹20 per tablet, my lord, next month we will get it at 40 rupees. That is like this. Anyway, my lord, my humble submission, where is the error of jurisdiction?
That is business development module. You see, because of the fact that now you tend to purchase it from internet, from so and so, you get discounts. So where do you think discount comes from? You have to pay for the discount.
Actually, some medicine shops are giving discounts also, my lord.
That's what I'm saying. You see, in a case, have you seen an abnormal profit of 10%, 15% to offer you a discount? So the discount is paid by you. It's a,
Now, my humble sir, with regard to this case, my lord, the court will not look into the facts, whether these facts are necessary or whether these facts are not important. The court will look into the ground. What are the grounds in the amendment petition and what are the objection, my lord? Their objection is only belated stage and trial started. After 2002 amendment, my lord, only ground is that is the trial started and party has not properly explained the delay. Here, my lord, the learned trial court clearly stated what are the facts and why this delay was caused. And during these things happened during the pendency of the suit. Miscase may be there. Miscase will not degree or help the plaintiff in the suit. So it is necessary that some facts should be incorporated in the plaint and that should be proved. And this Supreme Court fully support the case of the plaintiff. So your lordship may be, if at best, my humble submission, sometime maybe given to the trial court that the suit should be disposed of as early as possible. And the remaining, and if they want to proceed with the amendment or facts or any other further evidence, they will adduce it as early as possible. Because this is a suit of 2011, right? 2011. Perhaps, my lord, I could not submit more judgments, my lord, because it's 2022 or 2023. These judgments are all sufficient. And it covers all the earlier judgments, my lord.
Only thing is the law. For amendment. Again, they will get some for evidence. Sometime and because they are earlier version also. Then again we will have to find them or evidence. In meantime,
you have a chance to make Guinness Book of World Records. Bhuval, you can surpass Bhuval Sannyasi's case.
Yes.
There were, how many witnesses?
7 and they have
No, in Bhuval Sannyasi, I think 806, 800 and 300, 1100 or something. No, that is why one side. The other side was there. I think it will go to about more than almost nearly 1000 witnesses examined. So you have a chance to have another world record here.
Already they went +7. 19 witnesses are there. Meantime, they will also die million.
No, I'm just giving you an opportunity. You may create a new world record again in the state of Assam.
several defendants, my lord. Only this amendment is only against the petitioner.
Anyway, madam. Anyway.
Okay. I'll pass orders in the chambers. You may get it tomorrow.
Should I find this Justice Omita Bro in judgment matter? That is not reported.
No, there's another classic order. Authored by Honorable Justice Roy. This is a case of Mahila, no, it's Supreme Court judgment of Mahila Ramkali. In that judgment, after 2 rounds of Supreme Court, the litigation traveled 2 rounds in the Supreme Court. Amendment was allowed of the plaint by the Supreme Court based on interpretation of a legal provision. It says that the legal provision entitled him to another remedy, which is not even the pleaded case of the parties. And he found out that law and said that there's some right accruing under that law, particular law. Because in Andhra Pradesh, the land which is what is a land bestowed under a certain act, it can't be transferred. But a right is created under that. So those were the issues which came up before the Supreme Court. And after 40 years of the plaint being filed, 2 rounds of Supreme Court, amendment was allowed by the Supreme Court. But that was an order which would be under 142. So that is one of the classic cases in amendment. Oh, this is a application you have returned. You look what you have done in this application. You have highlighted all this in the petition. No, you'll have to file it. It won't come. So we have returned it this to you. You file it again. You have closed it. You see, you have highlighted everything. This is the petition will not entertain. So we have returned it. You come it afresh. We have given you liberty. It's not dismissed. You have just returned it. You file it and then new one you can file it. Returned. Plaint, petition returned.
Please file,
Pardon me?
please file. I have to file, please.
You have to file fresh. It can be returned and then you can file it again. Like liberty we have given. Because you have highlighted the those portions. We won't accept that highlighted portion. Correct? Item 14. Yes, for enhancement.
Yes, no. Yes, Your Lordship, where there is a delay in filing the claim petition, and that is why the same was not entertained, Your Lordship, of 5 years. New section 166(4) of the limitation act, Your Lordship, which says it has to be filed within a period of
So there's already, I think, a judgment.
6 months.
I think there's already a judgment that it's non-condonable or something.
Exactly, Your Lordship. However, Your Lordship, may I submit, Your Lordship? There is a judgment of the Kerala High Court. Your Lordship may kindly peruse that.
Akshay Raj, Your Lordship, versus Ministry of Law and Justice. Downloaded from the High Court page, Your Lordship. May I read a full? Page 9, Your Lordship.
9.
9.
Yes.
Section 163 does not exclude the applicability of the Limitation Act 1963, and therefore the provisions of Section 29(2) of the Limitation Act 1963 would squarely be applicable for the reason that on perusal of provisions of subsection 4 of Section 166, it is evident that even in the absence of claim referred by the claimant, the claims tribunal shall treat any report of accident by police or investigation officer forwarded to it under Section 159 as an application for compensation under this Act. Section 159 enjoins an obligation upon the police officer during the investigation to prepare an accident information report demonstrating the settlement of claim in such formal manner within 3 months containing such particulars submitted to the claim tribunal or any other agency as prescribed. That an MST ignored to refer to the provisions of Rule 150A of the Central Motor Vehicles Rules 1989, describing the procedure for holding investigation of road accidents arising out of the use of motor vehicles to be in accordance with the Annex 30. The manner of submission of forms, including electronic submission of such portal, has been specified. As per Annex 13 sub rule 2, investigation officer can furnish a copy of the detailed accident report within a period of 90 days of the accident, and in case it is not filed within the period prescribed for the reasons beyond his control, particularly in cases of hit and run accidents, cases where the parties reside outside the jurisdiction of the court, where the driving license is issued outside the jurisdiction of the court, or the victims have suffered grievous injury or have been undergoing continuous treatment, can approach the case tribunal for extension of time to file interim accident reports or detailed accident report, and on receipt of such application, tribunal has the power to extend the time as it considers appropriate in the facts of and circumstances of the case. Since this court almost every day has confirmed with such petitions requested, so it's done it. So senior counsel of this court to assist the court, Mr. S. Sri Kumar Dhanel, senior counsel, assist the court, submitted the provisions of Section 166 of the Motor Vehicles Act do not specifically exclude provisions of Limitation Act. In support, he relied upon the following judgments and keeping their part, Your Lordship. Then para 7 at page 11. May I read? Para 7, it was considered Section 5 of the Limitation Act only deals with the application and the appeals and not with the suit. The expression claim petition is synonymous with the applications, and therefore an aggrieved person would mean legal errors or true present and cannot be deprived of claiming the compensation if not preferred within a period of 6 months, as has been done in the impugned order, because there is no specific ouster of applicability of the provisions of the Limitation Act. Connected with this, some other original petitions, so and so, I'm keeping that part. Para 10, Your Lordship. Section 166 of the Motor Vehicle Act reads as under. Also skipping that on 11, on perusal of the provisions of subsection 4 of Section 166, there is not a single whisper which exclusion of the Limitation Act. Thus would not exclude applicability of provisions of Section 29(2) of the Act 1963. The aims and objects of the Act is to be referred later. Leave no manner of doubt that the legislature incorporated and caused the amendment by reimagining subsection 3 of Section 166 for ensuring that the claim for compensation of death of the claimant does not evade and can continue by the legal representative but within 6 months from the date of occurrence of the accident. Rule 150 then explain, Your Lordship. I'm next, Your Lordship. Para 14 at page 17.
Just. Motor Vehicles Act. And these rules, motor vehicles rules. You heard Mr. T. Deodan, counsel for the petition, for the appellant. Issue notice on this, issue notice of this appeal on the respondents, returnable on so and so. Just say that. The next part, also issue notice on the officer in charge, Tinsukia Police Station, to produce a proof of, to inform the court as to whether the accident information report under Form 54 in connection with Tinsukia PS case number 1452/18 under section 279/338 IPC was furnished to any person eligible to claim compensation as required under Rule 150 within bracket 2 of the Motor Vehicles Act. And or whether any request was made by any person eligible to claim compensation and whether the prescribed fees has been paid. Full stop. The the registry shall hand over a copy of this order to the Office of the Learned Senior of the Office of the Senior Government Advocate of Guwahati High Court, who shall transmit the copy of the order to the officer in charge of Tinsukia Police Station, which would constitute a notice to the said authority to do the needful in compliance of the order. Let the records be called, including record of Miss MISC within bracket MSc bracket close 247 of 2018 from the member comma, MACT, comma, Tinsukia. List on so and so.
Deep your bed.
You take back this return, you can address her on the next date.
Supply
You
56.
see, this is an appeal, I'm issuing a notice. But on the next date, you be prepared on the point. You see, that's why I've written that, quoted that. This Kerala High Court did not take notice of the subsection, sub-rule 2, which says that the application shall provide copy subject to applying and 10 rupee fee being paid. Correct. So, because somebody has died in a road accident is a established fact. And therefore, claim which is not, this Form 54 is not applied for. Whether there would be a duty or not for the state to provide that is one part. The second part is that if you have that notice, then the limitation would expire otherwise. Now, the Kerala High Court has built up the case on the premise that cognizance of 150, Rule 150 was not taken. But according to what we have read, I have said 52 requires your compliance. So whether that can be what you call condoned, that is one part. Second is, it is because of that 150, the Kerala High Court says that it would come within the condonable zone. So if that goes, the second part also goes. So be prepared on that point on the next day. Today I'm issuing a notice. Yes. 56. Non-appeasement call for the appellant. Issue notice on this appeal filed under section 96 CBC, which is preferred against the judgment and decree dated so and so, page 1, flag. The appellant shall take steps within 2 days for service of notice on the. Just before that, you say the appeal is admitted for hearing. I call for the records. The appellant should take steps within 2 days for service of notice on the respondents by registered post with AD as well as by usual process. Give a date of appearance. After 6. 7. Stay application, you say that non-appeasement call for the applicant. When Judge Justice the matter stands John today, same shall be take this matter along with the connected appeal. $57. Just a moment. Oh, this is that, yeah, 2 days back that matter came. Yes. We allow your application? No, I understand. You see, don't start from that same place. We were there on 18th on that day. We told you. You take somebody's advice. You have a lot of 4,000 friends here. Take. Yeah, John, you take a decision because this is, we wanted to help you. No, not day after tomorrow. It goes after vacation because we are overburdened these days. There are a lot of administrative works to do. Yes, what do you say? What
One
would be
decision.
appropriate?
One decision, my lord, perhaps, my lord, she can look into that. That's, my lord, in 2000, my lord, 8, my lord, SCC. 12 SCC, my lord, page 112, my lord.
What does it say?
But it says, my lord, that the cause of action, my lord, on the date of the cause of action arises, that the law that is applicable at that point of time, that will prevail.
No, does it say if it is filed again?
My lord, if it,
Cause of action it will not survive.
but the cause of action will be the date of accident, perhaps, my lord. That's where, my lord,
That is the issue. That is the issue. Because allowing is easy. I'm ready to allow it.
we'll keep the limitation point, open, my lord.
No, we can't do that because the limitation is something which is not extendable
Not extendable.
in an original proceedings.
Yes, that's not extendable.
Which comes to my mind is can withdraw and liberty be split into two parts.
There's no two parts. The withdrawal is withdrawal simpliciter. Because
Allowed out as a whole or rejected as a whole. So permission is granted for withdrawal, but permission not granted to file. Yeah, fresh.
we file it, we'll say that we are saying that you file it. But it can't extend limitation. Liberty to withdraw has been given, so you have withdrawn it. That is struck off the records. Where is the order? Where is the order?
Page 21.
Case is dismissed on withdrawal. Okay, then we give liberty, but we say that
So the petition says, my lord, petition, the prayer says, my lord, without withdrawal with liberty. Petition, of course, our petition says prayer was given maybe with a liberty, prayer with liberty. Petition is page 19, man. Petition has been next, my lord. That's in there, my lord. Page 19.
Your order is at page number 90.
Order is, petition 19 is a petition, if I'm not wrong.
okay, heard. Okay,
In my case, it is, my copy that you have given is page number 19.
Order dated 10/2/2022. There is written screen for withdrawal of the case due to some technical defect. And long
heard Miss M. Bharti and counsel for the appellant. As well as Mr. M. Dattaran and counsel for the respondent number 1. Next, the case of the this appeal under section 173 within bracket 1. No, sorry, first proviso to section 173 of the Motor Vehicles Act is filed to challenge the legality of the order dated 10/2/2022 passed by the learned member, MACT number 1, Kamrup within bracket metro, bracket closed, Guwahati in MACT case number 1 of 2018. Next para. The case of the appellant is that on 5/5/2022, an application was filed before the learned tribunal to allow the appellants to withdraw the claim petition with liberty to file afresh. First off, it was projected that there was a defective filing as the and that the appellants of the claimants were residing far away from the said tribunal. Full stop. Accordingly, prayer was made to allow withdrawal of the application. Full stop. Oh, no, sorry, that is wrong. This petition is on 10-2, 10-2, not 10-2. On the basis, no, then they correct it on the ground that there was some technical defect and the, oh, no, it's same. Then, so we withdraw this. According to prayer was made to withdraw the case with liberty to file afresh. Full stop. On the strength of the said petition, which was numbered as petition number 412 of 2022, the learned tribunal by order dated 10-2022, while allowing withdrawal of the claim petition, did not pass any order as regards the second part of the prayer made by the appellants to be granted liberty to file afresh. Full stop. Accordingly, the order to dismiss the claim petition on withdrawal has been assailed by the appellants. Next para. The learned counsel, Mr. M. Dattal and counsel for the respondent number 1 submits that he has no objection to the prayer made by the appellants. However, he has pointed out that notwithstanding that the prayer for withdrawal and or to refile it again be granted by this offer for withdrawal granted by the learned tribunal and allowing of leave to the appellant to file a claim petition afresh, it was submitted that under subsection 3 of section 166 of the Motor Vehicles Act, it contains a non-abstantive clause to the effect that, inverted commas, no application for compensation shall be entertained unless it is made within 6 months of the occurrence of the accident. Full stop, inverted comma closed. So hence it is submitted that the as per his opinion, the cause of action would still remain the date of action, the date of accident. Hence he claims that, hence he prays that the respondent number 1 be also granted liberty to take up this plea. If so advised, on refiling of the claim petition. Next para, considering the nature of prayer made in the petition dated 10-2022. comma, the prayer made in this appeal stands allowed. In exercise of appellate jurisdiction, comma, this court permits the appellants to file a claim petition which was permitted to be withdrawn by order dated 10/2/2022 passed by the learned member, comma, MSCT number 1, Kamruk Metro Guwahati. Full stop, however, comma. The next para, however, comma, the court also grants leave to the respondent number 1 to take such plea in defense as they may be so advised, including the issue of limitation. Full stop. We are granting that liberty.
This party's name was not mentioned. Again, we have made review of this order. But in the review, the correction, they didn't make the correction regarding.
So once it is dismissed, you can't do anything.
Liberty was sought for this.
No, no, no. You see, the order, the withdrawal was ordered on 10/2. After 10/2, the court becomes functus officio. I can't touch that file and allow you correction of the cost title on in a petition of filed in May. You see, when I close this application, can I entertain this application just for emptying of parties? I can't do that. Even if this court, in its wisdom, closes a matter on withdrawal, after that, we would not have the jurisdiction to touch that application and amend and insert parties. It would be, it can only be done in a list which is subsisting. We can't do that. No, 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 it's not so easy. You see, when you're dealing with the issue which you have raised, you'll have to have a broad idea of conspectus of various things. Number one, you should have a broad idea of what section 21 of the Specific Relief Act says. You should be aware of the provisions of section Order 1 Rule 10 2. You should also be aware of the provisions of Order 1 Rule 10 4 and Order 1 Rule 10 5. Without these 4 provisions, we will not be able to answer your query. You read that, you will understand. We have allowed it. We can't, you see, you can't, you can take both the stand, the number one, because that order, if there's no order, we can't take up a challenge. We can't take up a challenge. That's why you said you take a conscious decision. That day we adjourned it only for your benefit. We permitted you to take a conscious decision. You see, conscious decision would mean everything. Number one, in a dead matter, it's just like in a dead matter, you want to impede some parties. After the matter has been withdrawn, can I pass an order? Let us say today we have allowed your appeal, correct? Now you come up after a month and say that in this appeal, I forgot to impede someone. So please add parties. Is it permissible? Or do you think it is permissible? First of all, then that answers your query. We can't do anything. We can't.
Before the passing of the order.
Pardon me?
Prayer for.
No, that is 10/2. Your order was allowed on 10/2. Your application came on in May.
Lordship, there is one line written due to some the praying for withdrawal of the case due to some defect due to some technical defect.
No, that we don't know. You see, no. You will have to rectify it and then say the technical defect, you withdraw it and file it. So if there is any defect, you rectify it when you are filing it. The court has permitted you to withdraw it and you do whatever you want. You withdraw the petition, you do whatever you want. it's not that your application is returned. There's a difference between return of plaint and the return of a withdrawal of an application. So that's why I said, when you are making a submission, you'll have to have a broad idea and then do it. You see, you all young generation is the future of the court. So you must be more thorough with the legal knowledge than us. We are fading away.
Yesterday, I started reading CPC now. Yesterday onwards, from yesterday onwards, I started reading CPC with meditation.
No, do it because CPC is something I do it even now. After 30 years, I'm still reading CPC. And I can assure you, what I'm saying is correct. It's not only a mere statement. I read CPC Evidence Act almost daily. And when I'm taking up bail matters, when I'm vested with the bench of criminal, I always read CRPC daily and dutifully. I can only share that much. When I'm taking up civil matter, CPC is a daily reading, not only once. And I do it for last 30 years, I've been doing it. But do it, if you have started, do it, continue it. Because I can tell you only one thing. As a young lawyer, I can tell you only one thing. You see, if you know CPC, you can traverse to CRPC. You can do anything. You can also do writ petitions. You can do anything. Any foray into any field of activity a lawyer would have. You can do chamber practice. You can do corporate lawyer. You can draft only and then survive. You can only. There are lawyers who can survive only on doing affidavits in the CGM court. People who are doing only drafting a sale deed or doing affidavits in the CGM, they may be earning more than what most of the lawyers here would believe. But if you don't have the basic understanding of CPC, it will be very difficult to see. I can, if time permits, I can, what you call, so time will not permit. But if you come to my chamber when I am free, I can tell you that there are not less than what you call, it would run into multiple numbers of provisions which you are required to know when you are even moving a writ petition. Non-general necessary parties, impleading order 1 rule 8, this what you call cases when you are filing against a minor, issues relating to family, those things all emanate from CPC. Correct.
But it has answers to almost every conceivable situation, perhaps, almost everything.
Perhaps because substitution on everything in a writ petition, you have to do it.
Eventually, that might arise if it has answers to that matter.
And you're fortunate in this room, there are several stalwarts. 1, 2, 3 in this side, I can notice. I'm referring to stalwarts, not that doesn't mean that I'm demeaning others, but I'm referring only to stalwarts. They have a different, they are in different category. This side also I'm finding 2 stalwarts. They are there. You can take their assistance whenever you require. And the people who are sitting in my left and your right, they are the ones who have guided me all throughout in my career as a lawyer. So.
Can I ask one thing? Really has troubled me all my life. When
Your life is not yet over. You are a young man. Don't say what you like.
The code of the High Court conflict with the CPC, then in a writ petition or in any other case, what will it prevail? I mean,
substantive law will always prevail. Rules will have to, in an exceptional circumstance, a rule of procedure. You see, it's a rule of procedure. In a rule of procedures, which are both, CPC is also rule of procedure, and this is also there. So far as you can harmonize and take effect of it, that is okay. But I don't find that I've come across any situation where the High Court rules are traversing beyond CPC. It's not come to my notice. But these are all procedures and handmaid of justice, so therefore it can apply as in insofar as it is not inconsistent with this procedure. The CPC will prevail because of the fact that also, although we say it is a CPC, it's a procedure, but in fact it is an act. It's an act of 1908. What is that act? Act 1. The CPC is an act. It's a misconception that is a procedure. It's basically an act. So act will have supremacy.
Sometimes nowadays there is a thing that in this petition, there is completely different set of.
No, I don't know. I won't comment on those because unless you give me a specific problem, I won't be able to say that. You see, the first section says, this act may be called Code of Civil Procedure. So that is section 1. So it is the act which will prevail. It is misconception we are having that it's only a procedure. It's an act, in fact. So then you will have the answer. Correct. Now, yes, item 55.
Right.
In that, but I'm in the injunction application, I can issue a notice because I'm not inclined after the dismissal of the suit to grant an injunction.
Because I am a right item interest holder on that.
No,
Because
but once you see the,
two exhibits are there proof, madam. One the job.
no, you see, that is okay, but we'll issue a notice. Once the suit is dismissed to grant an injunction, the privacy case is lost.
I am not asking anything, no, they will not sell the property. That much, but if they sell the property, everything, they may not alienate the property, I am not asking. Still, they may not alienate the property, and they are willing to alienate.
Okay. In that matter, what is it item number?
Item number 56.
56. You add Mr. P.K. Roy Chaudhary, counsel for the petitioner. And then this I, you write, that Mr. P.K. Roy Chaudhary, counsel for the applicant. This is an application under Order 39, Rule 1 and 2, by which the applicant, who is the plaintiff in the suit, has prayed for ad interim injunction, inter alia, to restrain the opposite parties from alienating the suit land till the disposal of the appeal. If you notice, steps within 2 days, postal receipt, track report. Next, heard the learned counsel for the applicant on the prayer for interim relief. It is projected that that notwithstanding that the suit of the applicant has been dismissed and the decree of dismissal has been assailed in the connected appeal, but the applicant is the holder of right, title, and interest in respect of the suit property. And in this regard, he has referred to Exhibit 5. He submits that as the suit has been dismissed, if the suit property is alienated during the pendency of the appeal, the applicant would suffer irreparable loss and injury. Now, you just tell us one more thing. You see, once the suit is there, then application of 52 comes. So whoever purchases that suit property would be bound by the decree. So how you are prejudiced?
Ultimately, there will be a multiplicity of suit. Again, then there will be other impeding of parties and others.
Okay. Next, it is further submitted that notwithstanding that in respect of the subsequent purchaser of a suit property, the provisions of section 52 of the Transfer of Property Act would have application, but it would further entail multiplicity of proceedings because the future owner of the property would have to be impleaded for efficacious relief. This is something we can't digest, but still we have accepted it because you see, he is bound by the decree. It doesn't say, 52 doesn't say that you will have to be, he'll have to be implemented. So it goes contrary to the concept which I am having. If somebody comes, you see,
But after taking over.
no, I'll tell you what will happen. If somebody comes in as a owner of the property, then his devolution in the suit would not be under any other provision but under Order 22 Rule 10. Correct? And Order 22 Rule 10 is merely a substitution of the original defendant by another defendant, being the owner of the property on devolution of property. And therefore, it will be his onus to step into the shoes of the owner and claim, and therefore,
Single.
no, it's okay, but we are accepting, we are issuing a notice, but it's something which is not otherwise palatable.
They have been out of the end of 23.
That is why you are getting that benefit. Be that as it may, as the as the applicant claims to be the right title owner of the right title and interest holder of the suit land, comma, notwithstanding that the suit of the applicant has been dismissed, comma, but he has been able to demonstrate prima facie right to the prima facie claim against the suit property. Therefore, the balance of convenience also tilts in favor of the applicant so as to preserve the suit property till further orders of the court. First off, if the suit property is alienated, comma, third party right would be created, and therefore there is likelihood that the applicant may suffer irreparable loss and injury. Next, accordingly, till the next returnable date, the court is inclined to grant ad interim injunction restraining the opposite parties from alienating the suit land. Next, the distance so and so.
I'm sorry, my it was called. I was not.
So this item 55 will call delegate data. There's a matter to be taken up in chamber. The parties to the chamber proceedings may kindly come in.
Lots of and indulgence. Item 38, that day, that matter they came, withdrawal of the money and a claim. My friend-
From the other side to be here.
Yes, but let me take it up after the break.
Just a moment, before this that personal appearance matter will pass orders. What is this IA 18544?
Correct, I filed it as IA after the camera, in camera. I filed after camera proceeding. I have given the details regarding the proceeding and my opinions also. So against that, she filed in the reply. I also regard to my rejoinder.
Mr. Paul, this interlocutory application has to be dismissed. We can't permit this application to be on record. This, what you are saying is can't be brought on record.
My lord, it is fixed on another date, otherwise my senior is there. Because in their presence, I engaged this Mr. A.K. Putesto. So in his presence, maybe whatever. Otherwise, I'll be.
Mr. Paul, let me be very frank with you. You see, even today, we made an endeavor to listen to you and to see that the matter, which is a matrimonial dispute, in the matter of two learned counsel of the court, we wanted to intervene so that it can be brought to a quietus. Correct. Now, in course of our deliberations, many things would have been uttered in in-camera proceedings. You see, there are two types of in-camera proceedings. Number one, we take up a matter on the judicial side and the in-camera proceedings. That is one side. The second is that we take up the matter for just a chit chat to understand what the events are about. Now, if you go to this order of the court, you see, the intention was never expressed in the court to have these deliberations made a part of record. It was not a proceedings as such which was conducted in camera. It is only an endeavor to interact with you in the in-camera proceedings, because you see in the court proceedings, when it relates to matrimonial matters, the relevant laws permit the court to take up the matters in camera, so that it is outside the audience of anybody else. Correct. Now, take an example. In a particular matter which is before the court makes certain observations, or the lawyers make certain submissions. Correct. Every day we find in the news, in the newspapers, in the TV, one part of the court proceedings are displayed 100,000 times a day, showing that the honorable judge has said this. Now the question is that the deliberations which I am making, right now I am giving a monologue. Is the intention of the court to make this a part of record? Tell us. We are now deliberating. No, it's okay. No, you made a request that the counsel should be there.
Yes, my lord, that is why
No, that's okay.
I'm not,
But you are a petitioner in person.
it is not today because of my lord.
No, that I don't know.
Personal
Today on
experience,
record, you are in
that is
petition in
why
person. I am asking you a question. Because you see, the question I am asking you is whether every deliberation made in the court or every utterances made by a judge or a magistrate in a proceedings, is it with an intention to make it a part of record? Because you see, if I keep everything to myself, you won't even know the reason why I'm dismissing your application. Supposing I don't interact. Now I stay like a judicial magistrate first class without opening my mouth. Everybody comes and complains to me that the judicial officer was hearing me, did not react, and then my application was dismissed, no questions were asked, no interaction. I was just saying, making my argument, and then the judicial officer was not interacting, and then my application was dismissed somehow on the ground which has never been taken. This is something which we are dealing with it daily. So you want the courts to behave like that, like a statue, to just hear you and then pass orders according to the own wishes? It's not. So we make certain observations, we make certain comments, not with an intention to make it a part of record. Correct? If the court wants to make anything a part of record, it will be recorded in the order. That is one. Second is that it is a part of record. Who says so? You say that whatever I have stated in my application should be made a part of record. Now, what is the evidence before us today that this was uttered, this had happened in the court in camera proceedings to be made a part of record? You see, this is basically a civil application. It's a matrimonial dispute. In a matrimonial dispute, a CRPIO has come, and so therefore it partakes a character of a civil dispute. Where did you find that a civil dispute, in a civil dispute, the oral proceedings, wherever it has been taken, should be made a part of record? You see, before, let us say, a title suit, a dispute between two people claiming 3 lachas of land for a road. There is a dispute with parties. Now the Gaonpura comes, the people come and they say that, okay, we'll do that, we'll do this. Now, can you come in a civil suit and then say that, well, when the dispute started at that point of time, before the Gaonpura, before the ladies of the village, I made that submission, the other side agreed to that, and now they have filed a suit. So the transcription of what has occurred in 2012 should be made a part of record. Is it how we proceed in a suit? Is it how we proceed in a matrimonial proceeding? Because then every time we'll have to start from 1965. There's a dispute between two couple, and then they come and no, we were married in 1990. So in 1990, this has happened. In December 1, this has happened. In January 2, this has happened. January 10, this has happened. Because I'll remember each and every date of what has happened when it comes to dispute, whether right or wrong. The spouse will also remember each and every date, whether it happened or not. You will say, one day she did not give me to sleep. One day she, did not give me food. In one afternoon, I did not get my tea. So is a matrimonial dispute or a civil dispute structured on verbal information of what had transpired? You see, it may be, since you are a petitioner person, it may be the litigation may be personal to you. But I'll have to view everything dispassionately. We have no feeling when it comes to adjudication. I may be hanging a man to death tomorrow. So if I decide things with compassion, everything would not come to a logical conclusion. At times, compassion is required, yes. We don't say that compassion is not required. But to what extent? How can we permit? You see, something which is being transpired in the court and in camera proceeding. Number one, essential party is one of the honorable judges who had made an attempt to resolve the dispute. Now, in course of proceeding, whatever has transpired, if you want to bring it a part of record, that would lead to a very anomalous situation where a judge becomes a witness. Then tomorrow what we will do is that I have made this statement, it's a part of record. Now please call the honorable judge to become a witness. Absolutely easy. You disturb the entire fabric of the the court proceedings. You take away the liberty of the court or a judge or a magistrate to speak openly. Will it be in the interest of justice that a court should not open the mouth? A court should not express any opinion. A court should not deliberate with the lawyers. If the court has any query, it can't be put to the court. Because tomorrow somebody will come up and state that, yes, in Mr. Paul's case, you made it a part of record. So in that case, I made a statement that I may be given this relief. You did not make it a part of record. So I become the subject matter of ridicule in every court proceedings, just because I don't know how to keep my trap shut. I'm calling it a trap because now we are in a trap. You are asking this to be made a part of record, deliberations of what had happened. You see, let us forget this. come to the second part. You see, what is admission? You read Evidence Act several times. What becomes an admission? Can an oral statement made before Gaonpura that, okay, I will leave 3 feet of land becomes an admission? Is it admissible in a court proceedings? A statement made without an intent to make it an admission, can it be an admission? Can we convict someone on the basis of extrajudicial confession, which is later on allowed to be retracted by an accused person? So what according to you is admission? If something which is not admission, why should it be made a part of record? So you see the goodness of the court of deliberating with you to allow a matrimonial dispute where you are personally involved to come to a quietus is now being made a weapon of assault to the court. The goodness is replied by an assault on the court, requiring those proceedings to be made a part of record. That this transpired when I was speaking to the honorable judge in the courtroom, in the chambers. Should I be subjected to that kind of scrutiny? This is absolutely an abuse of the process of court. The interaction of the honorable judge out of the goodness to have an attempt to resolve your matrimonial dispute because you are an officer of the court. We know you, we have seen your conduct in the courtroom. We thought that it should be appropriate that we try to make an amicable solution to your matrimonial disputes. You see, that is why I am very cautious. On the last occasion, we said that the lawyers were not welcome, but still today we permitted the lawyer. Today I had a court staff with me when I was sitting there interacting with you, so that any unsavory situation which arises, at least I have a proof that an independent person was there in the courtroom. Our lawyers were there, you were there, and the court staff was there. It is only just an intuition which allowed me to allow your lawyers inside, with intuition which allowed my court staff to be there when I was interacting with you in in-camera proceedings. But today, tomorrow, somebody may come and say that, no, when I went to the chambers of Justice Surana in a matrimonial proceeding, he abused me like this and that. He wanted me to accede to the, the proposal of my estranged spouse. He told me this, he told me that. Should I be subjected to that much of scrutiny in a proceeding where I am making an endeavor to have the settlement made? I may have made some utterings which may not be to your liking. Some statement of mine may have been due to dislike of your spouse, estranged spouse. Would it make me the subject matter of scrutiny in a proceeding tomorrow in a judicial scrutiny in the matter which there is no intention of the court to make it a part of record? If I have the courage, I will make it a part of record. I will dictate in my order. If I don't have the courage, I will not reflect it, because it was not intended to be a judicial proceedings, first of all. You see, in an MSCT case where you are more acquainted, the judge will ask him that, okay, whether this would be sufficient or not, whether that much would be sufficient or not. And let us say the injured person says that, well, okay, 10 lakh would be okay. And then tomorrow you bring it on record that no, when the judge asked him, he made that statement before the court that 10 lakh would be okay. Now he can't be granted 12 lakh just because he made an admission on that day. Is that how we go with the proceedings? Tell me in a subject matter which you are more acquainted, MSCT case. Now, kind of question and answer by the judge and the victim. We made a part of record to make it an admission that no, your claim cannot exceed to this X. But this is something which all the judicial officers do day in and day out. We may say when a petition comes, oh, we don't have a case. And then you say that we bring it on record saying that no, on that day when today is 19th or 20, when the matter was moved, your lordship expressed an opinion that you don't have a case, and then your lordship issued a notice of motion. Therefore, what you did was not in accordance with good conscience. You will attribute motives to me. Every day I say you don't have a case, and then when you convince us, we issue a notice of motion. Will it be made a part of record just because it has transpired in a court proceedings? Should I be subjected to that much of scrutiny? I don't think so. Everything which transpires in court cannot be made a part of the proceedings. What are required to be penned down is it's a proceedings which have been drawn up and written and made a part of record in the order sheet. Everything which transpires in the court is never intended to be a part of the judicial proceedings of a court. Here you'll have to reply because you see the advocate will move on your instructions. You may be a counsel, but today when you are here, you are a petitioner, the applicant in person. The lawyer will move at your what you call instructions. Lawyer can't come up and say that no, I have instructed and the client is running like that. If the lawyer has the courage to say so, please let him say so. Then I will show him.
Necessary for.
No, it's okay. But you tell us whether the lawyers are running operating at your instructions, or it is at the instructions of the lawyers that you are moving this application.
It's correct.
Then I'll do something which will not be favorable to you.
It may be possible today.
No, you do it, but you see, you still have to respond to it. You have signed it. Affidavit is yours.
Yes.
Now you tell us, as an applicant in person, I am asking you, should I be made a scrutiny of that amount of scrutiny should be made to a judge so as to curtail its independence in the judiciary?
Because I'm not prepared that. So might not give me the time.
You do it because if it comes to this, if I am to adjudicate, this is the question I'll be asking you. If something which is unsavory, it's absolutely unpalatable. Now, do you want me to make a part of record? I'll rather make it. But then you'll accuse that the court has said so much things, wasted 15 minutes of time, 20 minutes of time, and did not make it a part of record. So I'll rather make it a part of record. Because this is something to a disliking of the court. I should not be made subject to that much of scrutiny when the intention is not bad. The intention is to have a matrimonial dispute settled. So we have said something. Your spouse may have said something, conceded to something. It's a part of mediation process. Unless that mediation is drawn up and made an agreement, there's no admission. And when it comes to section 89 and the mediation provisions, you will understand that whatever has transpired in a mediation is not required to be made a part of record. The only recording required is whether there is a settlement or not. What happened during the conciliation or settlement proceedings is not required. It is prohibited to be made a part of record. It's not taken. It's not accepted as what you call. It will not be acceptable with grace. Heard Mr. R.C. Paul, so the applicant in person also heard Mrs. R. Chaudhary, London counsel for the opposite party. Next paragraph. It appears that in course of the proceedings of CRP-IO 60 of 2023, having noted that the parties to the litigation are lawyers who are practicing before this court, an endeavor was made to have the proceedings taken up in camera. Full stop. It is projected that certain deliberations took place in the in-camera proceedings. And by this interlocutory application, the prayer of the applicant is to make this interlocutory application a part of record. Full stop. At the outset, the London counsel for the applicant in person prays for an adjournment so that the matter can be addressed by his engaged counsel. Next para. With the presumption that the advocate holding a brief would act in consonance with the instructions given, and on noticing that the petitioner in person is present, the query of the court is that whether it is as accepted judicial procedure that every utterances made by the presiding officer of a court or a tribunal be made a part of record, and whether statement made by litigants before the court when questions are asked by the presiding judge is intended to be made a part of record, and as if there was an admission which is beyond the scope of the definition of admission as provided under Section 17 of the Evidence Act 1872. Again, a supplementary query of the court is that whether an attempt of the concerned judge before whom the matrimonial proceedings are placed, which is akin to or parallel to attempt to mediate the matrimonial disputes by the court, whether the intention of the court was that anything transpired during the court proceedings should be made a part of record. So these queries are essential, are deemed essential because in course of proceedings today, these were the questions asked to the learned to the petitioner applicant in person, and therefore he may again accuse the court of not making deliberations which occurred in the court a part of record. Full stop. Therefore, the applicant or his learned counsel shall address the court on the issues raised in this interlocutory application in light of definition of admission as given in the Evidence Act. Next, for the learned counsel for the applicant is also put to notice. The applicant is also put to notice to address the court as to whether it would be in the interest of justice that that a judge or magistrate before whom the list is pending be rather silent and pass orders without interaction with the counsel, merely to protect and insulate himself from an attack by a litigant accusing the court of not recording what had transpired in the proceedings. Next para. So, on the prayer made by the petitioner, the applicant in person, this matter stands adjourned today. List on. Give a date after vacation.
In one.
In this CRPIO,
Not 19, any other. 22. 20.
in the CRPIO, you say here for the petitioner here, Mrs. R. Chaudhary, learned counsel for the petitioner, and Mr. R. C. Paul, the respondent in person. Next paragraph. Pursuant to order of this court dated 4/12/2023, comma, the matter was taken up in chambers so as to implore upon both sides to have their disputes settled through mediation. Full stop. On interaction with the parties, comma, the both have expressed their willingness to have their matrimonial, to have an attempt to settle the matrimonial disputes through mediation. Full stop. Therefore, the court is inclined to refer the matter to the Guwahati High Court Mediation Center so as to appoint a trained mediator to mediate the dispute between the parties. Full stop. The mediator would have is initially provided 30 days. The 10 total days will go from a make it 45 days from today to make an endeavor to mediate in the matter. So it would be open to the to the learned mediator to seek extension of time if there is a possibility of a settlement. Full stop. The issuance of individual notice to the parties is dispensed with, and the this order itself being passed in the presence of the counsel for the petitioner and the respondent in person would constitute sufficient notice to the parties to attend the mediation proceedings. Next paragraph, the first date of mediation is fixed on 4/1/2024. Or you are both here, we can give it day after tomorrow, it will not be possible. 4/1/2024.
4/1 just after, like 2 days back.
5. On 5/1/2024. 45 days from 5/1/2024, not from today. 5/1/2024. Next, let this order be sent to the Guwahati High Court Mediation Center so as to enable the said authorities to make arrangements for appointing a trained mediator in the matter and to facilitate the mediation proceedings. First mediation at 5 at 11 a.m. List this matter on
22nd.
It will be 9/2/2024. This IA 1845 is different date, huh? This IA will be taken up separately. We have fixed a date. On that date, this IA will come, and this mediation will be the by which time the mediation report shall be sent to the court.
Taken up on 22nd. 22nd.
Yes.
Well, criminal petition may be take together. It will be take together.
Which one?
Criminal petition matter. I file a criminal petition.
Criminal petition. Just a moment. Let me come to it. Okay, heard in the criminal petition, heard the petitioning person and Mrs. R. Chaudhary Leonard, counsel for the, here you appear. Oh, okay. Then you write, Mr. B. Sharma Leonard, APP for the state, appearing for respondent number 1, and Mrs. S. Sharma Leonard, counsel for the respondent number 2. Full stop. Separate order has been passed in a tagged matter being CRP IO 60 of 2023, referring the matter to referring the dispute between the parties to be to be settled through mediation. Full stop. So accordingly, comma, as mediation is permissible for all the material disputes, comma, the same would cover the present dispute arising out of complaint filed by the applicant, sorry, opposite party number 2, the respondent number 2. So according to this matter would also be an attempt would be made also in this matter for settlement through mediation. List
26.
on the same that what do you call 9 to 2024. This goes. There is another matter? No.
No.
Okay. Anything else? Any other order to be passed? No. But we take an exception because these things are curtailing the independence of the judiciary. You'll just because of you, I can't change my character. If I stop interacting with the lawyers, I can assure you in hundreds of cases, it will be lawyers who will be affected. They won't get a chance to give a reply to the court queries. Because in certain subjects, I would have the capacity to decide even a second appeal without hearing the lawyers, without asking any queries. And think of that day, what would happen if I stop interacting with the lawyers? Today, at least we have some deliberations, we have lawyers coming up, preparing themselves with case laws and then coming up. So if I stop interacting, I won't suffer. That is guaranteed. Because I don't have a conscience. I won't suffer. I would have a good night's sleep even after doing whatever I want in the courtroom. It will turn me to be a dictator in the courtroom on the subjects which I know well. I have a tendency because you see power corrupts and absolute power corrupts absolutely. And it's not that we don't know how to corrupt ourselves. Corrupt ourselves means even what you call, not in the pecuniary terms. Corrupt ourselves means if I don't interact with the lawyers, don't hear them, that is again a form of indiscipline, which is again a corruption. I have a tendency to do it, I can do it. Correct. So don't push me to that aspect where just because of your application, it is the entire community which will suffer. It will be 4,000 people who will be suffering. Just take note of that. Because when I take up a jurisdiction, I make sure that that I will be at least acquainted, if not knowing the subject. Just tell me, I can be that. I'll tell you something today. One of the honorable judges in the initial stages called me. Will not call me, we meet at times on occasions. One of the honorable retired judges, we interacted. And he says that, Mr. Surana, what you are doing in the courtroom, I find that your, what you call the disposal rate is only 4 or 5 matters a day. With you, we were expecting that you would have disposed of 20, 30 cases a day. I'm telling you, this is a fact. And when you find that I prepared the last of the cases in the board, you find me with the interaction. You don't think that I don't have the capacity of disposing of a matter without hearing you. Correct. You have experience of appearing before the Supreme Court. You have had experience. You have not have experience. Ask two people who have appeared in the Supreme Court, and then tell us how much time you get to open your mouth in the court proceedings before the Supreme Court. We have the capacity to do it, but I'm not doing it because I come from the bar. It is my intention to see that along with all the members of the bar grow. That is why these questions. I give you an opportunity to interact. Otherwise, the bar will not grow. The young generation who are the future, they will be hesitant to appear with the court and make submissions. Because a junior will have lost faith in the system. They say that our judge is not asking anything, he's just dictating the orders. So if I change my character, it is the bar who will be suffering, and I can guarantee that. You may have interaction with your friends in the bar. They'll tell you. If I'm pushed to that extent, where I'm cautioned of every question I asked, because tomorrow everyone will come up and say that your lordship had that view and therefore make it a part of record. It will lead to me to shut my trap and then proceed with the matter, and I am capable of doing it. So better withdraw it, because if it comes before this bench, it will not be so easy. That's why I've written in my order. I've shown you that I have an ability to write what I'm thinking. The queries which I am put to you, I had the courage to write in the order sheet and make it a part of record. So these queries are now in public domain. It can be subject to scrutiny all over the country. That this is what the question is. The debate will start now from tomorrow in WhatsApp. This is the view of the judge. What is your comments? And then all this media, social media will be now after me. I'm taking the risk of that. It's something I'll dislike. I'm sorry to the members of the bar. I've taken time in this matter because this is personally affecting the freedom of the court. That's why. No, I don't know, but you see, I have a board to complete. I have a board to complete, so therefore I have to seek an apology from the members of the bar. Correct. It's my duty to do so. Yes, item 55. Yes, Mr. Sharma.
Yes, better also, inadvertently I failed to attach one document. Here reply in our petition. So I'm seeking some time also to find that reply. After that. Otherwise it shall be a suppression from my part.
Just tell us what is that document. We'll see if it is required to be adjourned for that ground.
This is the reply, Lordship.
Huh?
But this is the reply to my, the case is there, in the Deputy Court Tribunal, they filed one application against the petitioner.
No, that is, you see, that is not a subject matter. Why I'm asking you to disclose what document it is. You see, give this to him. See page 396. It's superintending jurisdiction, correct? In page 397, you will find a list of tribunals and courts which are under our administrative, what you call superintending jurisdiction. Is Devstigori tribunal there? So 227, it will not lie. As simple as that. Because orders of the Devstigori tribunal are subject to appellate jurisdiction. So if there is any infirmity, it has to be corrected by the appellate tribunal. How will I assume jurisdiction under 227? That is the query of the court. Okay. So see, this is again an example of what I said earlier. Correct. If I keep my trap, no, it's okay. But what I'm saying is that if I keep my mouth shut, you would not even know what is coming to you. Correct. No, I'm just telling you as a member of the bar that if I stop interacting, this adjournment we would not have got. Correct. The purpose of adjournment is that we want a deliberation, a healthy deliberation. We'll adjourn it, don't worry. Huh? We'll close it. Okay. Heard. Mr. R. Sharma, Honorable Counsel for the petitioner, as well as Mr. M. Sharma, Honorable Counsel for the respondent. Number for the respondent. Next para. By this application under Article 227 of the Constitution of India, the petitioner, who is the defendant in the proceedings of OA number 388 of 2022 before the Debts Recovery Tribunal Guwahati, has assailed the order dated 19/9/2023 passed by the presiding officer, DRT Guwahati, by which, number one, prayer to file written statement, evidence on affidavit. No, only one. There's only one. Affidavit by recalling order dated 10/2/2023. Was rejected. The learned counsel for the petitioner has submitted that there was a genuine cause for not being able to file the written statement within time allowed. But the learned tribunal did not consider the matter and had passed the impugn order, for which the present challenge has been made. Next para. That is chapter. What is the chapter? Although it has been brought to the notice of the court that there are instances in the past where interlocutory orders of the Debts Recovery Tribunal Guwahati has been visited by this court in exercise of jurisdiction under Article 227 of the Constitution of India. But we take notice of the Guwahati High Court Superintendence of Tribunals Rules, 1992, which has been framed in exercise of powers conferred under Clause 1 of Article 227 of the Constitution of India, whereby the Debts Recovery Tribunal has not been included in the schedule appended to the said rules. Full stop. In absence of conferment of jurisdiction under the Guwahati High Court Superintendence of Tribunals Rules, 1992, the court is not inclined to assume jurisdiction under Article 227 of the Constitution of India in respect of the challenge to order dated 19/9/2023. So accordingly, this application stands closed. However, liberty is granted to the petitioner to approach the appropriate forum and take all such points which has been agitated in this application. So with this said liberty, this application stands closed at the motion stage without issuance of notice on the respondent.
Alright.
Fifteen.
Item 15.
This case which seems whether I will get some. It seems whether that notice or issue before admission of the case and will ultimately appear. The question of law that arises here is whether at page
9.
9. The only question that can be assailed or ours is question number 2. I don't see the other question comes in. Here, this is an appeal by the plaintiff who has lost in both the court. He filed this suit for the purpose of a decree, possessory decree, that he has the right to possess the land and he should not be affected. The defendant was filed a written statement and a counterclaim also, stating that they are the owners of the land and seeking my eviction.
You are the plaintiff or defendant?
Plaintiff.
You are the plaintiff.
Plaintiff sought a degree for permanent position at page 16. As per the tenancy right.
Because I'm intrigued with this question, number one. That is why that question. You see, the substantial question of law number 1 is whether the learned court erred in law for holding that the plaintiffs and their predecessors staying in the suit land are permissive occupiers as consented by so and so. So you are questioning your own occupation over the suit land. Is it so?
No, he has the learned courts below, both the courts below, have decided this issue against me. saying that it was by a the consent was given by a minor.
Yes,
Therefore, this is not applicable.
yes.
This is not correct. And it was invalid.
No, but you see the question,
But he has held that it was a permissive occupation.
no, that's why you are the plaintiff.
Right.
So you are questioning the decision.
Because it was held against me that it was not valid. The permissive occupation was not valid. Permissive occupation of it with the tenancy right.
No, no, now when you're saying I'm getting it, but you look at the question here.
Yes.
After 1972, it says, inasmuch as when both the court below had held that the precision was minor in the year so and so, and as per law, consent is no consent at all.
Right.
So that means you are questioning that.
So I am questioning on number 2 only. That
Okay.
I had long possession. Uninterrupted possession. What that will be? Do I have an adverse possession? In the appellate court, I asked that. Appellate court had rejected it after the judge of the trial.
But that would only be academic because you see, if I can give you this, Limitation Act Section 6, the legal disability. So
So
you
I'm
see,
not arguing that one.
no, what the point which I'm trying to ask from you is that, you see, let us assume that you had been occupying during the minority of the predecessor of the defendants. And the defendants have filed a counterclaim. But that counterclaim would be within the period of what you call, if you can't show the date on which he attained minority or majority, then Section 6 says that the legal disability of his being a minor would be a period which is excluded in calculation when the suit is filed or a counterclaim is made.
Yes.
That is one. Second is that after that Ardwatia case, first name I am forgetting. I am remembering Ardwatia. That after that Ardwatia's case, it has been clarified that the cause of action to file a counterclaim would accrue on the day when this counterclaim, when the plaint is filed.
Print is filed. And
So therefore, you see that period of limitation would otherwise be curtailed, would be otherwise accounted for from the date of legal disability till the filing of the plaint. And therefore, whether he is a minor or not, if in a suit, because in a minority consent can be it cannot be
at that point in
acceptable
time,
because that is there in the Contract Act. Consent of a minor
Yes.
is otherwise excluded. So therefore, if the limitation is curtailed or accounted for between that time, the discussion on minority would only be an academic discussion.
Yes. I have not that.
You take it some other day.
Yes.
This is again statement which I am reiterating. If I don't interact, you see, the lawyers will not
No,
know what is hitting
The
them.
interaction is necessary.
It's necessary because
Otherwise,
if
we make a complaint and the judge doesn't say anything. I don't know whether he is hearing me or not, or he is admitting my petition or not, or he is dismissing it.
correct.
And we always say, the judge is dismissed of a petition without hearing.
Without hearing me.
Yes. Hearing means discussion.
No, that is why that question is haunting me. I think it will, for some time, it will disturb me. That last matter. Okay, we adjourn this, Mr. Sharma. Mr. B.C. Das, counsel for the senior counsel, assisted by Mr.
Yes.
S. Paul, counsel for the appellant, and Mr. A.C. Sharma, the senior counsel, assisted by Mr. S. N. Brahma, counsel. So on the preliminary senior counsel for the appellant, the matter stands adjourned today. So it is noticed that in this, that that this appeal has not yet been admitted on substantial questions of law. So therefore, both sides would, sorry, the appellant side would address the court on the substantial questions of law on the next date of listing. List after.
After the automatically.
Choose the date, senior counsel will accommodate the dates, which we are normally not accommodating now, and to others you have those liberties.
Second week, whether 9th or 11th,
See the convenience of Mr. Sharma,
9th or 11th.
9th?
No, 9th.
Okay, 9/1/2024. Next item is 17. Mr. Das, I'm sorry to call you back. How's your health now? Okay. Is disturbing you now?
My mind goes faster than the body. That is the problem.
Uh,
Mentally, I'm okay.
No, I understand. You see, we respect the age. That's why it does slow down, but ultimately it is the what do you call yesterday. Yesterday in that interaction where Justice what do you call it, this Amitabh Chaudhary Memorial Lecture. There's a good word was that whatever your age be, you must lead your life to the fullest. So you can only pray that you be graced with that.
That is what I want to
uh,
but that my last days should be here.
correct.
That is my desire.
Yes, 17.
I'm praying for a withdrawal of the appeal. The grounds we have contended in the appeal discuss absolutely into this context. So I'm praying for withdrawal.
Okay. Mr. H. Buragoyant and counsel for the for the applicant. Upon instructions, 6 to withdraw this interlocutory application as well as the connected unregistered appeal. First of the prayer is allowed. This interlocutory application as well as the connected unregistered MSc appeal under filing serial number 270340 dated 62/2016 stands dismissed on withdrawal. Eighteen. Yes, what is the ground? How you have explained the delay? How have you explained the delay? Please speak loudly. I'm unable to hear you.
Okay, he's not being able to present today. So.
You're seeking an adjournment. Oh, how is his health? He's okay. Okay.
Okay, Lordship, you can also finally go to office note dated office note dated 12th of October. Lordship.
Yes.
Service AD card with respect to respondent number 1118 and 110 has have been received back. But with respect to the other respondents,
Oh, acha. Thank you for pointing it out. Ms. M. Kalita, Learned Counsel for the applicant pays for adjournment. Mr. A.D. Chaudhary, Learned Counsel for opposite party number.
now Lordship 2 and 3 Lordship.
For 2 and 3.
Respondent number 1 had expired Lordship, so they have preferred that substitution petition.
2 and 3 is present. And he has referred to the office notes of this matter. Next para, it is from the office note dated 12/10/2023. It appears that AD card in respect of opposite party numbers 1 within bracket Roman 2, 1-8 and 1-10 are received after service, which however AD card in respect of notices issued on opposite party numbers 1 is common. 1 within 1, 3, 4, 5, 6, 7 and 9 has not yet been received. Was from the process service report. Is found returned with a remark that the address of the opposite parties falls within the jurisdiction of PS Mankachar, South Sarmara Mankachar district. Next, therefore, the applicant is directed to take first steps for service of notice on the opposite party numbers. The same 1, 1, 3, 4, 5, 6, 7 and 8. In connection with this, no, not required. The notice is made returnable on, give a fixed date after 6 weeks. Notice made returnable so and so, list on the said date.
Right.
Yes, should we open this brief or not?
I beg to take time as my senior Mr. T. Islam is still undergoing treatment.
Okay, because it's taking us some time to open this brief. That's why we asked. Just a moment. It's a matter of which year? 2020. Cause this two. What is this IA for?
IA is for setting aside condonation of delay notice and setting aside.
For substitution. We'll allow these applications. Any objection to it? Serious objection to substitution?
We want to file an objection.
You want to file an objection?
17.
But is it not too late to ask for time? It's a 2020 matter, this application. And the second appeal is of the year 2003. 2003. It's a 2020 application. Condemnation of how many days?
In 2020 application, setting aside amendment 163 days.
163 days. So for 163 days, we have already crossed 1000 days. Why should we waste time on these applications in a old pending case? You are appealing for whom? Are you aware?
Respondent number 1 to 7.
Respondent 1 to 7. This application is for whom? Respondent numbers?
Respondent number 5. Notice is taken 1505
1505, yes. Is for?
for setting aside amendment, delay in setting aside amendment.
No, for whom? Respondent number?
5.
5.
That it came to one.
Just a moment, just a moment. We are allowing this application. We'll hear the matter on merit. We will refuse your prayer for adjournment. Heard Mr.
M. Gogoi.
M.
Gogoi.
Gogoi, learned counsel for the applicant. Applicants and Miss K. Das, learned counsel opposing appearing for the opposite party numbers 1 to 1 to 4 and 1 to 4 and 6 and 7. Next para. At the outset, the learned counsel for the appearing respondents had prayed for some time, prayed for an adjournment on the ground that the learned counsel holding the brief is not available. Next para. This interlocutory application has been filed under Section 5 of the Limitation Act. On 3/3/2020 for filing an application. In filing an application, condemnation of delay of how many days?
163.
163 days beyond the period of limitation in filing the connected application for setting aside abatement and application for substitution of the legal representatives of this is respondent number 5. Next panel. The projection made in this application is that the death of respondent number 5 came to the knowledge of the applicant only in February 2020. But and is also alleged that the counsel representing respondent number 5 had not informed the learned counsel for the applicant of the demise of respondent number 5. Full stop. We have perused the order sheet of this court in the connected RSA 169 of 2003. And it appears that there is no order of the court in the said in the connected appeal recording the information about date of death of the respondent number 5 in the court. Full stop. Ordinarily, the counsel appearing for the parties are expected to inform the court about the death of a party as required under Rule 10 capital A of Order 22 of the CPC, which casts a duty on the counsel to communicate to the court about the death of a party. Full stop. It is not in dispute that the present set of counsel appearing for the opposite party numbers 1 to 4 and 6 and 7 was the learned counsel appearing for respondent number 5 before his death. Full stop. The same having not been done, the court finds that it's a fit and proper case for to accept the accept the statement made by the applicant. Next para. Ordinarily, the court would have granted an adjournment to the opposite parties to respond to this application, which was paid for. Full stop. However, in this case, as the court does not find that the communication of death of respondent number 5 in the connected appeal was communicated to the court, the and taking note of the fact that this application is pending for adjudication since it was filed on 3/3/2020, the court is inclined to disallow the prayer for adjournment for filing of objection, and this application for condemnation or delay stands allowed by condoning the delay of 156 days beyond the period of limitation in filing the connected application for setting aside abatement. Same grounds will be there in this. What is this other applications?
1504 is setting aside abatement.
1504. 1504 is setting aside abatement. And
1502 is the condonation of delay in substitution.
okay, same order in this, only limitation will not be there. This court finds it sufficient ground to uh,
1501 is for substitution.
why two applications are registered for the same purpose?
But response number 3 also, right?
No, this is not for 3.
What's the delay in substitution? 150, logic is saying or 1502.
1502 is application for substitution. We don't need a substitution application there, condonation application.
Once this code is observed,
No, I don't think so. Limitation is required only for setting aside abatement application. It is not required for, because if that is condoned, your application with it for setting aside abatement under 22 rule 4 and this substitution under rule 3, they can be taken up independently. Mr. Jain, am I right? There's only one application. For every application, you don't need to support it by applications. Only for abatement. That order will be then in 1505. This 1502, you'll have to write that this is an application under section 5 of the Limitation Act for condoning a delay in filing the substitution application. Full stop. The said application appears to be misconceived in view of as the court is of the opinion that application for condonation or delay is only required for taking on board the application for setting aside abatement, if the same is delayed. The same is not filed within the time allowed. According to this application stands closed as unnecessary. Dismissed as unnecessary. Or make it closed. I don't know, make it closed. 1502. Now this 2 goes. Then comes
1504 is setting aside.
1504 is setting aside abatement. 1504, same thing, will accept delay. Then 1501 is for substitution. It's allowed. And the RSU right, in view of order passed today in IA Civil 1501 of 2020 and 1504 of 2020, the registry shall complete the substituted legal representatives of the deceased the respondent number 5, whose particulars are available in the set to interlocate the applications. First off, next para issue notice to the legal representatives of respondent number 5. This is returnable on so and so. 9.2. The applicant shall take steps for service of notice on the substituted respondent numbers 5 within 2 days. The learned counsel for the applicant, postal receipt number, track report, list on so and so.
Another respondent, there is also right. Also may take up 2032.
2032. 32. We'll take it up next day. We'll allow her adjournment also. Correct. In one we have allowed, we allow her also. Correct. What is that biscuit? 50-50? In that, what application?
For substitution.
No, what is the number?
032.
2032 of
17.
on the prayer made by council, you write a name, application adjourned today, list after answering. No, this one, it will be yes, 9/2/2024. Twenty. Yes.
At the outset, I have to submit that we have filed a reply, rejoinder in objection. I have found that it is not in the record.
Oh. No, because we have taken an exception to that, because the delay of condemnation is 60 days, 6 days. And it has been kept lying in court for 6 years. So
Whatever.
that's- no, whatever is their reason, we'll see your
Yes,
objection when
very
it
good.
comes.
It is
Uh,
our fault, whatever, the check I have given, scheduled deposit, that was missing. I had
No,
to
it's
pay.
okay, it's okay. If, let that objection be on record. Mr. S.C. Viswas, then counsel for the applicant. Submits that objection to the reply to the objection raised by the learned, by the learned counsel for the opposite party has been filed, which is not on record. First, Mr. I. Hussain, counsel for the respondent numbers 2, 3 and 5 to 11 is present. List after ensuing winter vacation. The registry will take the objection filed by the applicant on record. Make a mention if it doesn't come, because we are unable to manage the board immediately after opening. After view, we can give a date. Okay. After view, wait 22nd, 22nd. Okay. 21, 22. Just a moment, just a moment. Just a moment. Yes,
As per official gazette, 15/12/2023, LCM has been received. Kindly please take value.
15/12/2023. Records have received
15/12/2023,
and
LCM has been received. Kindly please take value.
no, is service complete? Service complete. So this has to go for hearing.
Okay.
Okay. Miss
Miss A. Hussain.
A. Hussain, counsel for the appellant. And Mr. M. Dattal, and counsel for the all the respondents.
No, but respond number 2.
For the respondent number 2 is present. By referring to order dated 23/5/2022, as well as office note dated 15/12/2023, the learned counsel for the appellant submit that the case is ready as regards service and the LCRs have been received. Accordingly, let the matter be listed for hearing in the month of February 2024.
In one case, I'm one, and in the other case, I'm 2, respond number 2.
In
One case, I'm respond number 1,
in 44, you are 1.
1. The other one,
In 44 is 1,
Thirty.
and in 34 is number 2. No, it's okay. He is not denying that, but the numbers are different.
Numbers are
Okay.
But good that you have seen the office note. It lessens my work. Good done. Good work done. 23. 23,
My lord.
yes.
Adjournment on behalf of RK board of the engaged counsel for the applicant. Due to some medical emergency led to Rajesh.
The matters, last time also adjourned on his prayer. This is RFA. Just a moment.
And I
Okay. You have to convince us on this application. He'll adjourn it, let him make his submissions.
the month of September also, this matter was.
I said that he has taken adjournment twice. This is second time it's being adjourned.
Lordship says whether petition under order 1 rule 10 will be applicable or.
No, you see, you are not affected. His suit was dismissed.
Yes, my
Correct. The more the adjournment, you are more happy.
lord. Today, in fact, my learned brother has also contacted me and informed that.
No, it's okay. But once the suit is dismissed, you should be more happy. Correct. You should encourage adjournment for not 1 month. You should encourage for 3 months.
No, my lord.
No.
No.
You're not an encouraging person. No, no,
I also
okay.
need an early
Okay.
so that nobody should suffer.
Okay. On the prayer made by Mr.
Yes, sir. Yes, sir.
A. Sharma, counsel for the applicant. The matter stands adjourned today. Mr.
B. Bora,
B. Bora,
for respondent 1 and.
counsel for respondent numbers 1 and 2 is present. List after ensuing winter vacation. Make a mention if it is not listed. Because we are at difficulty immediately after vacation.
Right.
After winter vacation, again, there is a view vacation.
Yes.
We list matters in after reopening and all pairs for adjournment to come after view vacation.
24.
Yes, RSA.
Whether the applicant has suppressed many materials and many things have been done, but I was ready for.
No, no, today you are not, earlier, because I was allowed some time to file a substitution between your lordship and this, performance was 1 and 6 your lordship. But I communicated with the party, but we get no information with your lordship, sometime maybe allowed.
You are the plaintiff for the defendant?
Performance,
No, you are plaintiff for defendant? No, appellant, I understand. You are plaintiff for the defendant. She's
She is the applicant defendant.
defendant, okay. You got a degree of khas position,
Yes.
okay.
6 cases have been filed by them, all the cases they have lost, only killing crime. But
I am told that never stops. It is good that somebody could kill time. No, just a moment, just a moment,
that's
just a moment. Who has expired? 1 and 6. Okay, Ms. A. Begum, Learned Counsel for the appellant prays for adjournment. Mr. M. U. Mahmood, Learned Counsel, appearing for respond number 1. Objects to the prayer for adjournment on the ground that the execution of the decree granted in favor of the respondent number 1 has been stayed. Full stop. Accordingly, the Learned Counsel for the appellant shall take notice that the matter would not be adjourned on the next date of the still.
Your Lordship.
Okay. Interim order is in IA, huh?
I, Your Lordship.
Hers also. On the prayer made by Learned Counsel for the applicant, the matter stands adjourned today. So M. U. Mahmood, Learned Counsel for the opposite party number 1 is present. So in the connected appeal, an order has already been passed that the matter would not be adjourned on the next date. List. This is second appeal, give a date after the vacation.
(22-1).
Your Lordship.
27, item number 27.
As per office note dated 29/7/23.
Just a moment. Yes.
Respondent number 1, 2, 4B, 4C, 4D, 4D, 4P, and 4H. They have filed their wakalatnama.
You are appealing for them? Yes,
Respondent number 3 and 5 were duly served.
yes.
And Lordship 4A and 4F has expired. You have to substitute them. And the others, Lordship, service is not complete.
Yes.
Lordship, I would request to take fresh steps on those.
No, because this is something we have already recorded in our previous order. So we merely adjourn the matter at your prayer.
Take steps, Lordship, and
On that, we may not say anything. On the prayer made by Mr. C. Sharma, counsel for the applicant, the matter stands adjourned today. Miss
FN Jaman.
F.N. Jamal, Z.A.M.A.N. Counsel for the opposite party numbers 4B to 4G and 4H. It should be 4B to 4H. Is present. Your call? And Mr.
And Brahma.
And Brahma and counsel for respondent number 1 is present. Only one. 1 and 2 is present. Full stop. List after ensuing winter vacation. For steps, you are not saying anything. It is your liberty to do it. You are not saying anything.
28.
Service part is complete. It is once this acknowledgement I received from the registry today, Lordship, the service has been completed.
Service completed.
Yes. Except for the copies. And lower court record has also come up.
No, let it be recorded in the order sheet because it's not there.
Yes. Can we,
No, it will be the office who will have to record it.
Yes.
Yeah.
No,
Uh,
Lordship, I have one prayer, Lordship. In appeal memo, Lordship, two mistakes that has come up, that's in page number 5, Lordship. Exhibit 3, it should be, Roman 3,
Just a moment.
appeal memo. That is to be need to be corrected.
Which page?
Page number 5 of appeal memo.
5 of appeal memo, yes.
B, it is the exhibit 3, it should be.
Okay,
And in D, issue number 2. Instead of 3, it should be numerical, is 2, Lordship.
okay, we allowed that, Mr. Smith, we allowed this. You are appealing for,
The respondent 1 to 4.
oh, so you are appealing for ESI?
Fine.
Oh, okay. You're for? 5 and 6. Mr. B. Sharma and counsel for the appellant submits that 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 he is instructed to inform the court that the notice is duly served on the respondent numbers, on all the respondents.
Accepted memo.
Full stop. Next para.
Submitted is a register.
Mr. M. Smith, counsel appears for respondent numbers 1 to 4. And Miss P.
P. Maharshi. Lordship.
Maharishi, learned counsel enters appearance for respondent numbers 5 and 6. Mr. Accordingly, the case is ready as regards service. Next, the learned counsel for the applicant. Sorry, appellant. Submits that there is a typographical error which is crept in respect of substantial question of law number A and C.
B and
Sorry,
and
B and D. B and D. And the, and that in respect of substantial question of law number B, capital B, huh? The reference, the exhibit in reference is exhibit 3 and not exhibit 2, Roman 2 and Roman 3. And in respect of substantial question of law number D, capital D, comma, the reference to the issue number should be read as issue number 2 and not 3. Full stop. The error being typographical, comma, the learned counsel for the appellant is permitted to make necessary correction in the memo appeal under his signature, and similar corrections should also be made in the memo appeal of the learned counsel for the two set of respondents. Now, what is your substantial question of law? That was page 5. The judgment order is issued to a non-consideration of materials on record. That is very vague. Whether the judgment passed is ignored documentary evidence. What are those exhibits 1 to 10?
Then I have exhibited the documents regarding that I am running LPG dealership and I am a proprietorship concern, and all along since the beginning 2002, I have obtained 5 numbers of employees. So in exhibit 1 to 10, Lordship, in case only Lordship come to the judgment that is Ah, 81, Lordship, page number 81. In all the documents, 5 numbers of employees are mentioned. Page number 81, trade license have enclosed, their Lordship exhibited, their 5 numbers Also, I've enclosed the certificate of labor inspector dated 28/11/2014 also. There were also 5 numbers of employees. Certificate registers of petition concerned. So the form Q, form number G,
Which page?
page number 81, Lord. Page number 81. All along, these are the 5 numbers of employees and even the wages registered, the day of offense also. I've exhibited that document of wages registered also. Prior to the incident and after the incident. The name of the 5 numbers of employees were already there. So my only concern is that I doesn't cover under the ESI. That was not at all considered. But it was.
Lordship may come.
Just a moment. Where is the document? Exhibit 2? Where is that?
Documents, also the evidence part, the appeal number. The documents has not been enclosed, Lordship. The judgment, the report has come up, Lordship. And the evidence, Lordship, I have, Lordship. This is Lordship.
What is the document? Just tell me what is the document?
This document is labor inspector and inspector under shops and establishment had issued certificate of Rosni's guest service. So and so owned by Shivaji Roy, registered from under the shops and establishment act in the office of the assistant division. And the 5 numbers of employees, the name are mentioned in the
Pass me that.
list.
That we are admitting it on the ground of perversity.
Your Lordship may come to page 75 of the judgment.
70?
5 of this appeal matter.
75.
5.
Yes.
One of the second last pair.
$75, yes.
Okay, if I may read, Mano, second last pair. Strangely enough, PW1 in his cross examinations has very candidly stated that the inspector of ESI authority visited the establishment in 2007, which is covered by the ESI Act. The admission of PW1 contradicts its own plea that the unit was not coverable in the year 2012. Palpably, PW1 having fully understood the question put by the standing counsel of the respondent made by the said admission. Needless to say that the facts admitted did not be proved as per section 58 of the Evidence Act. On page 76, Mother. Argument put forward by Mr. B. Sharma, learning counsel for the petitioner, that respondent failed to prove by the cogent and reliable evidence, and because the additional 12 numbers of workers, as mentioned in Exhibit 12A, has not been proved. As Mr. K. Guite, who has visited the premises of the petitioner establishment on 25/9, has never been examined to prove the authenticity of the document. The said argument of the learning counsel is not acceptable in the fact that the visit of the officer of respondent on 25/9 is not seen. The appellant himself have admitted that the his establishment comes under the ESI Act. And in page 78 also, in issue number 4, it has also been discussed. PW1, issue number 4, Mr. Lordship, page 78. PW1 in its evidence has.
No, no, just a moment. Where is the evidence in chief?
Not been annexed to the memo of appeal.
It's not there. No, Mr. Sharma, then your appeal would fail. You see, under the ESI provisions, once you are registered under the establishments, if your establishment is registered under the ESI, even if you're for a temporary period, if your employment falls down within that threshold limit, still you continue to be covered.
Noting that, what he said there, in my cross examination.
No, no, you see,
I am not in covered under ESI.
No, no,
I'm
no,
not
no.
covered under ESI. Don't
No, no, you
say
see,
anything till now.
you see, very, it's simple. Since I have not read it, correct? I have a tendency to hear so much and understand so much. It is wrong, but this is what I do. Correct? I may be wrong in my understanding, but you see what has happened. When I add few things in my mind, 2 may become 5. You see, the evidence in chief is not given. In the evidence of DW, he has stated that the survey was made in 2012, and along with the survey report, your establishment was made to cover on 25/9/2012 under code number so and so, which is there in page 3 of the para 3 of the evidence on affidavit of the DW1. So you see that this is a positive evidence of your establishment being covered. Once the coverage is there, you have to seek an order of exemption from coverage under the ESI Act. Sections I will forget because I have last so many years I have not dealt with it. So the exemption has to be specifically ordered by the competent authority. Huh? Whatever competent, I will not remember those much. So that having not been done, once establishment is covered, it continues to have the coverage whether your firm exists or do not exist. No, no. In the act, if it does not exist, the liability to pay would still would still continue. Unless there has been a golden handshake and this staff otherwise taken care of.
Is field day not covered under ESI? What happened, Lordship? Not covered. That allegation, I will come to that part also. The cross examination part I've enclosed. Lordship.
No, you see this. You see after that.
Yes.
The DW says he has produced those documents in their defense. Correct. Now, therefore, when the question is asked to a witness, and he says that yes, earlier I was covered till 2012 under ESI Act, that becomes an admission. You can't come out of it.
In that regard, the word that was the mistake type of, so that again I filed a petition. Court has passed order after correction the 2 points, the typographical mistake, because there must be substantive evidence to that. My whole case that I do not cover under the ESI. That was.
Where is that order expunging
I
that?
have enclosed that order. I have enclosed.
That has not been allowed. Madam. Page
83, no, hardly.
60?
Not allowed.
Page, kindly come. Page number 83.
Of the appeal.
Just let him complete. I'll come back to you.
Page number 83. also. Immediately, why?
Just a moment.
It has come to my.
Just a
Oh,
moment.
yes. Yep. And I also close the cross examination.
Just a moment.
Yes.
Sixty-three, yes.
83 lordship. will include.
83,
Yes,
okay.
lordship. And before that lordship, if it comes to page number 50, the cross examination is also there, lordship.
Of?
It will come. Page number appeal memo, page number 52.
Although both the cross section PW1 and DW1 I've read.
Yes. That have done, I have cross examined also, and PW1 as well cross examined.
No, he says in respect of the inspection memo, the witness says that except for exhibit 2, I have not given any other exhibit. That's why I saw that exhibit 2. But the fact that there is a coverage is also part of the exhibited documents.
That will come.
It's okay.
Before lordship, lordship, I will come to the page number 52 and the main part of cross examination of lordship come to page number 55 lordship.
50?
55 first.
Five.
DW1 whom I cross examined lordship.
Yes.
I have not annexed any document to show that I am the social security officer of ESI respondent. I have not submitted any document to show that I have been authorized to depose in this case on behalf of ESI. He says that by virtue of his charge of office, so he is empowered to depose all cases. I have not annexed the office order. In my dominance of it, I have not mentioned any office order regarding my authorization to represent the case. On 29/11/2019, I joined SSO in the management service in Guwahati, and the offense occurred in 2012. As SSO, I have gone through all the document, get to know about the cause of action of the case. After joining my service in Guwahati, I have never visited the premise of Roshni Gas Service Gas Agency Silchar. I do not know the name of the officer ESI who signed the written statement in this case. I do not know the number of respondents in the case. I do not know whether the officer ESI who had signed the WS in this case is in service or not. Mario Mary, in assistant director of ESI, I have got the case file from dealing assistant whose rank is below me. The file was put up. By the way, Exhibit 2 issued by labor inspector, 5 labors were named at the time of registration. Proceed. On 25/9/2000, the inspector visited the premises of Roshni Gas Service Silchar. K. Gutte was the inspector who made the visit. Our office has not issued any letter to K. Gutte to depose in this case. Our office also did not issue any notice to K. Gutte in order to sign the written statement. As per Exhibit 3, the labor inspector of service has mentioned the total numbers of laborers employees in Roshni Gas Service. As Exhibit 9, 5 numbers of employees were shown engaged in the said gas agency from the month of April 2012 to March 2013. As per Exhibit 3, K. Gutte asked the proprietor, Roshni Gas Service, for wage register. Office who signed the WS did not enclose Gazette Official Authority letter, as well as the office identity card to show that she was acting as assistant director. I am not aware if ASI filed any petition seeking leave of the court to submit the document at the stage of evidence which are not annexed at the time of WS. I do not know who wrote the names mentioned in the last part of Exhibit 2. Also, do not know who put signature. The person's name in Exhibit 2 has not adduced evidence in this case on behalf of ASI. No other document is submitted apart from part of Exhibit 2 to show the person, namely Jaidev Sikdar. This is Exhibit, lordship, kindly, the judgment. It is actually Exhibit 3 actually. To show that persons, namely Jaidev Sikdar, Diganta Das, Nisi Dev, Sumat Dev, Tejaram Tawau, Vinu Paul, Sanjay, Sibu, Rabindra, Rintu, Subhas Khanar, Muni were employees of Roshni Gas. It is not a fact that Roshni Gas does not come under the purview of Act and it does not have more than 5 employees. This Exhibit 2 is actually Exhibit 3, Roman 3. That mistake was occurred. Then I made a submission and the learning could be. The person who filed the WS has not come for evidence. The person who
made inspection has not come. And none other persons whose names are reflected in that Ellis letter dated 25/9/2012, nobody has come to give the authenticity of the said document. From where he has got. And to support my part, I've executed 10 numbers of document also and disputed that letter.
You have the ESI Act with you? ESI Act. Yeah. No, for you, no, I have it. That's why I'm showing it to you.
No, just- but I
Now you come to section 17. These officers of grade A and grade B, they are appointed with consultation from the UPSC, and therefore it is imperative that they are gazetted officers.
the knowledge of the incident.
No, that's okay. But when you are questioning the authority of the person, you see, these are gazetted officers, number one. Number two, you kindly have Evidence Act and see illustration E of section 114. I'll give you this Evidence Act.
I have it.
You have
Yes,
illustration E of section 114.
114.
Yes. All official and judicial acts are deemed to have been duly performed.
What in the court may presume the existence of a fact which it seems likely to happen?
Illustration G. Then there's a in middle, there's a illustration.
The evidence which could be.
No,
or
that is no, that is G. E, I am saying E. All official and judicial acts.
Judicial and official acts have been regularly performed.
Yes.
Yes.
So there's a presumption, even if there's no identity card. Incidentally, I can tell you I don't have an identity card. I never bothered to get one. I'm just telling you.
The question
It's just a passing remark, nothing to do with official act, but incidentally, I don't have a identity card. And I've been able to survive without an identity card for last 6 years.
part I'm not telling you. Just question was put in the question, but regarding the personal knowledge in respect of the letter which is released, in that knowledge, he has no knowledge to that part. And the name of the persons whose names are written in that document, that actually nobody has come up, that I am the employee, nobody has come up. So I dispute on the basis of the section
No,
67.
you're not getting the point which I'm trying to urge. You see, what I'm trying to ask you is that if by virtue of the provisions of ESI Act, the coverage is a adequate proof of your continuing liability. You see, let us forget any other evidence. If by mere coverage of under the provisions of ESI Act, if the liability act says that will continue, you see the official act or the lapses on part of the ESI will not what you call extinguish that liability. So first of all, if that registration itself under that act is not under challenge, the one which was there existing at 2012, subsequent coverage is a deemed coverage. We don't have to go to that evidence and find out who did this, who committed that error of writing, who did that, who did that. That is a what you call it will not be it will be a sine qua non for the sorry, not sine qua non, it shall be just exception to omit that and take cognizance of the coverage and then saddle you with liability.
I've never been covered under ESI.
Hmm?
I've never been covered under ESI. That is challenging just law.
But that evidence you please, that's why I'm saying, unless you see that evidence, you won't know that what is the evidence about. The DW has proved that coverage under code number so and so.
No, code number, let them has to produce that document as support to that party also. I'm not, that is my case from the beginning.
No,
Not
that is
because
there.
the case has come up
Mr.
with
Sharma, that
the
is
court.
there.
So I will, if it permits time, I will elaborate.
No, time is something I can always grant. You see exhibit 5, Roman 5 of the defendant. They have proved that.
The tendency of the case, they have.
Exhibit 5.
Roman 5.
Yes, exhibit 5 is the coverage letter dated 15/12/2012, which is annexed and marked as exhibit 5.
5/12/2012.
So that seals your fate unless you successfully overcome that. It will be a very difficult task to accept your submissions. Your all the substantial question of law will fail. No, I have the original one here. You can look at it. This 88 of the this particular LCR. It will be one. No, don't leak papers. We have kept what do you call this? What is that name of that? It's called liquor, I think. That leaking pad we've kept here somewhere. Asenai. We have kept a leaking pad there. We don't want our lawyers to be infected with virus. And you know the best part? I'll just address the house. I find Mr. Chaudhary and Roy Chaudhary there together. You see, we kept a leaking pad here. Somebody stole it. We had to get a second one. From the courtroom in the front, it was lost. First day we kept, we got a very good one, very good looking. And then next day morning, it was not there. So this is the second set of leaking pad we have kept here. And my court master had to give an explanation why second pad in second day. So Mr. Sharma will have to dismiss your application.
I will satisfy lordships regarding that part also. I will satisfy lordship. Any date kindly be.
Okay, you want an adjournment, okay.
I will satisfy because that everything has been. From
No, it's
their side,
okay.
that has been done.
It's okay. Adjourn it. Let him be
Written
prepared
statement,
on that
nothing
point.
was there, that documents.
No, it's okay. We are adjourning it. Again, reiteration of my first statement, that if I don't get a given opportunity to the learned counsel, he will be more aggrieved than I would be. Uh, on the Mr. B. Sharma, counsel for the appellant, and Mr. M. Smith. So write the names. You have written already. In the next part of the order, you write on the prayer made by learned counsel for the appellant. The matter stands adjourned today. List after ensuing vacation, winter vacation. Make a mention if it is not listed because We are not giving a date right now. It will becoming very difficult to adjust. Just a moment, Mr. Shamua is there. We agreed to upgrade his matter. We'll take that up.
Please, your lordship. IA 3412.
Who is for the insurance?
Yeah. Okay.
My instructions are not to object. It's his mind what to inform.
Okay, heard Mr. A. Samoa, counsel for the applicant, and Mr. M. Datta, Leonard, counsel for the respondent number 2. Who is for 1? None of this. Service is complete on 1.
My lord. Service, my lord.
In the connected appeal is,
I've taken steps, my lord, but I'm sorry, I did not see it.
no, take care. You have given short stamps. Stamps you have given, you're saving money at your cost.
Well supplied. This is actually steps taken.
No, I don't know.
by-
I have a tendency to speak in a lighter tone. I just told that you have saved money.
I'll do it.
Consequences may follow on the next day.
I'll do it.
Next para. If you have the order proposed to be passed, the issuance of notice on respondent number 2 is dispensed with. Next para. Sorry, 1 is dispensed with. Next para. By this application, comma, the applicant who is the claimant in the proceedings of MAC case number 2426 of 2017 before the learned MACT number 2, Kamrup Metro Guwahati, has prayed for withdrawal of the fixed deposit amount of rupees 3 lakh, which is kept in form of fixed deposit
In Assam Gramin Vikas Bank,
before Assam Gramin Vikas Bank,
Guwahati branch,
Guwahati branch.
account number 729,
Achha, bearing account number. This account number you will find at page 13. Huh?
it's page 729,
Uh,
8010034111.
comma, which is pursuant to the award dated 8/2/2023, passed in the said proceedings. Next, the learned counsel for the applicant has submitted that there's a medical emergency as he has suffered an injury of his right what?
Eye.
Okay, that you have not said here in para 4. In right eye, which is progressive and needs treatment from saving the other eye from becoming blind. And he's advised immediate surgery along with other investigations which are requisite, which are required before surgery. Next para. Although the learned counsel for the opposite party number 2 has reservations against the prayer made, comma, but considering the medical requirement for money, comma, the court is of the considered opinion that it would be in the medical interest of the applicant that the prayer is allowed. So accordingly, the court is inclined to allow the applicant, namely so and so, to how will you do it? How will you do it?
When that, the MSCT member, MSCT will,
That,
issue a letter to the bank. So
okay.
in case the,
okay, accordingly, accordingly, the court permits the applicant to move the MACT, to move the learned MACT number 2, Kamrup Metro Guwahati. And on receipt of such application, comma, the said learned tribunal shall make communication with the Assam Gramin Vikas Bank Guwahati branch so as to enable the applicant to withdraw the fixed deposit amount of rupees 3 lakh. In respect of account number, which is already mentioned herein before. Full stop. This application stands allowed. And disposed of. In the appeal, you write same, but now he'll be appellant and respondent number 2. In view of the office note, the applicant shall take immediate steps for service of notice on the respondents. Respondent number 1 by registered post with AD as well as by usual process. The notice is made returnable in 6 weeks. List after 6 weeks. Yes.
But in this case, I have taken steps by the service on 5 and respondent number 5 and 6. Then I have filed the affidavit regarding service.
You filed it. It comes after vacation then. Mr. S.K. Ghosh, counsel for the applicant, petitioner, has submitted that he has filed an affidavit of service of notice on respondent number 5 and 6, which is not on record. Miss M. Begum, counsel for the F. Begum, counsel for respondent number 1 is present. Let the said affidavit be tagged with record. List after ensuing vacation.
One. Service update so as for the MCL so
Yes. You are the plaintiff or the defendant?
But I was the plaintiff.
You are the plaintiff. What is the prayer in the plaint?
The prayer in the plaint was my lord for declaration of his vital interest, my lord.
And position.
And possession.
So, Mr. Roy Chaudhary, that interim injunction has to continue.
My lord, only thing, my lord, let me contribute, my lord. My lord, position, right title interest, both the courts has said there is no right title interest, no position on part of the plaintiff. My lord, our case is this, because of that interim order, the police is, we are in position, is disturbing us. Whoever is in position, the police may not interfere with our position.
No, they can't. If you can show that they have been interfering despite a civil court order, we would be taking a stern action against them.
There is no interference, my lord.
Well, the police is disturbing us, that is the issue.
No. You see, that is merely a statement. If the police will have, definitely they will have a name, number plate. We will be able to identify that person. If somebody comes.
Because your lordship may look into page 35, 73, 70.
No. You see, we will be assuming that the police is disturbing you merely on your oral statement. There is no affidavit to that effect.
My lord, in the affidavit in opposition, we have filed, my lord. We have stated that, my lord, in both the court, they have failed to prove the
No,
title.
that is okay.
Well, now, getting an injunction without a title and a position,
No, it is for preservation of the suit because that is the second condition of order 3901.
but only thing is that, well, I think there is a direction for not to alienate or like that.
Not to?
Alienate, I think, well, the injunction order is there.
No, it only says two things, not to undertake the construction work, nor they will change the nature and character of the same.
Well, I will not do any construction work, it's a agricultural land. But whoever in position, may, status quo, may, will also will modify to that extent of status.
No, you see, whenever somebody plays for what you call status quo, I immediately remember the case of Ketlachera Tea Estate, Katlichera. Correct? That comes to my mind. Status quo led to 3 deaths and 17 life imprisonment. I may be wrong in numbers.
Malad, only thing because of this direction, we have nothing, Malad, we will not.
But those were the days when I entered into the bar, and the first thing was that this multiple life imprisonment and this multiple sentence we used to hear in the courtroom.
Because, Malad, this IA,
Huh.
your lordship will find it has been passed on the basis of an injunction application.
No, that is okay. You see, but if you have to say that the police is disturbing you, there must be something more.
But, Malad, your lordship will also find the way the interim order was passed. Your lordship will find.
When I-
Issue notice, appellant take, and, my lord, till return.
When I see up, I see something in Delhi.
This is, I think, definitely because they are the plaintiff. This is an order under order 39. Without discussing anything of a prima facie case.
That is okay. You see, Mr. Roy Chaudhary, perhaps we can answer that.
Or the, my lord, related women as such, only your lordship will add whoever in position.
You
will not be
would not
disturbed.
like an answer.
My lord,
No, it's okay. You see, status quo leads to more difficulties.
I'm not
Because-
asking for status. Only your lordship will add to it, whoever in position will not be disturbed, that much. Not by written police or anything, not be disturbed, whoever in position. If they are in position or we are in position. That much.
No, just tell me. So you see, just tell me, tomorrow if there is an assault on you and a part of your land is occupied by someone forcibly, then what happens to the nature of order we are passing and what happens to the protection we have granted? So
Because,
somebody who can by show of strength can enter into the land. His
Yes.
position becomes perfected.
my lord, their right title interest and position was nullified by both the court, concurrent findings.
No, this will you file an application, we'll grant it, but file an application. You see, it leads to many more,
That-
what you call,
Learned friend is making submissions to the apprehension. There's nothing in this, no statement.
no, he's,
Definition of
you
position is not
appreciate,
for,
you see,
modification.
apprehension is not incorrect in making an apprehension.
And this
Correct.
order is on the basis of, my lord, your lordship has said that 52 and order 22 rule 10.
In fact, Malad, they were the one who were trying to.
No, we won't comment anything, because the point which Mr. Roy Chaudhary is making has substance. It is only the technical part where we are refusing at this stage. You file an application. Do it. Because you see, he is one of the party who is litigating. He will know more of the field environment than us.
In fact, the petitioner, Malad, the appellant, he stays in a far off place, he doesn't even stay there also. So all this apprehension, Malad, I'm allowed to only to complicate the issue.
Oh, no, we can't accept that. You know why? There is somebody in Pakistan right now who has been alleged to have been poisoned. And in India, we have an apprehension that he is the person who is doing this, doing that.
I can understand that, Malad.
Correct.
I can understand that. But
So,
yeah, Malad, the facts are not about it, what my husband.
no, I don't know. You see, I am not making any comment. I'm just saying that we have you see, the more we read, is more confused we get. So we are just asking for an answer. I'm just giving you the problem, that this is what I have read 2 days back. So what would be your answer to it? I am not offering an answer. Correct? Oh,
We'll
okay,
file an application.
okay. The matter is ready as regards service. You are appearing for all the respondents? Oh, you are also there?
No,
Oh, you're with him. Okay.
he of this.
Okay. Mr. M. Datta, counsel for the applicant, as well as Mr. P.K. Ravichandran, learned counsel appearing for the respondents. In view of the submissions made by the learned counsel for the respondents, the matter is adjourned today. To enable him to take appropriate steps, right? List after ensuing winter vacation. Please make a mention if it is not listed, because you are the plaintiff. You are basing your claim on the basis of Kacha deed.
No, man. I'm basing my title on the basis of my, my lord, inheritance. Man. That's well, the main issue has not at all been discussed by both the courts below. Kacha deed was never my contention, my lord, that the Kacha deed is my title in money. It's an admitted position which is an ancestral property, my lord, which was divided into two brothers. Man.
Page 33, my lord, last paragraph.
No, so something is wrong.
Court, my lord, both the courts, my lord, took the Kacha deed to be the title which I'm relying upon. It's totally, my lord, contrary, my lord, to my pleadings, my lord. There's only one line which was there, my lord, that has created the confusion, pleading, my lord, of not happily drafted, I can say.
No, something is wrong then. No, something is wrong. Because then what happens to exhibit 7? Why is exhibit 7 come into existence? It is plaintiff's evidence.
Yes, but exhibits, what happened, my lord? There was a understanding between the both parties. That
It's okay, I'm just asking you. We'll take it up when the matter is heard.
In fact, the admitted position is, this is an ancestral property, my lord, which was divided, my lord, between two brothers, my lord. I'll show that, my lord, because that's what Kacha deed, my lord, has been wrongly taken to be the title by both the courts. That's the entire thing has been, my lord, totally, it's totally perverse, my lord.
Okay, we'll see that.
I'll show that, my lord. In the real world.
Okay, we won't have time, I think. Oh, there are 2 criminal matters. Just a moment, there are criminal matters also pending. Item 32 and 34. This is for cancellation of bail.
Filed before the district magistrate. But I asked my client to collect the orders.
Okay. On the prayer made by Mr. M. Ali, counsel for the applicant, matters to adjourned today. Mr.
KK Das.
KK Das, learned APP is present. List after ensuing vacation as paid for.
Apply.
And ensuing winter vacation. It's 34.
States are the twin pendency of this, where the definition of the code. They made another application for other for submitting the fact. They might not,
34.
34 years fine. And release on bail bond. Can you also find,
Just a moment. Two six double two. He was granted bail where, in which matter?
twin pendency. What is available before it's honorable court. They suppress the affair given regarding pendency, file an application, because you find, page 11, man, in IA.
No, in which is that application? What is the number where it got the bail?
2648, 2018.
2648.
2648.
But then this application has to be tagged with that matter. It can't be taken up in 2622. In 2622, at best, you can file an affidavit to bring on record that this
No, no,
is.
This is fine only, this is only because of the being on record. Apply this honorable court. Regarding that, my not really pendency of the.
Acha, okay. But we are not issuing a notice on this. We just say that this will be, the prayer made here will be considered when this BA 2622 is taken up. Correct? We are not issuing a notice in this application.
Yet, 2622 is now infectious because he is enlarged on bail also. He is enlarged on bail. He is out of jail also.
He's on bail.
Yes, babe.
Also, the thing is that we are in this court because this court has rejected my application for twice. And we did not suppress anything with clean hand. We approach your lordship by annexing all the reject orders. But some other are there who doing malpractice, file a bail petition in another court, suppressing all the facts, and he got bail. This is the case.
No, but then
This is a very serious issue, lordship. It's a very serious lordship because we are doing honestly. They are playing with the code and all.
Sure. Mr. A.K. Sharma, learned counsel for the petitioner.
In this case, lordship is a petitioner. I.
No. In the bail application. Because this has to be closed. A.K. Sharma, counsel for the petitioner. This is in bail application. Has submitted that on a perusal of the interlocutory application being IA civil, IA criminal 1226 of 2023. Yes, it has come to his notice that the applicant has been released on bail
On 1/12/2023.
by order dated
1/12/2023.
1/12/2022, passed by this court in
1/12/2023.
23, passed by this court in BA number
2648.
2648 of 2023. So hence he submits that he was not aware of it. And he prays to, and he submits that in view of the grant of bail, this matter has become infractious. Full stop. it is, next para, it is put on record that to bring on record the grant of bail, comma, allegedly by suppression of facts, comma, the Mr. FKR Ahmed, counsel for the informant, submits that he has filed the connected interlocutory application being IA criminal 1226 of 2023 to bring said facts to the record of this court. Full stop. Separate orders are being passed in the connected interlocutory application. Full stop. Next para, be that as it may, as the learned counsel for the applicant is not, the petitioner is not pressing this bail application, or this bail application being BA 26, not because this bail application stands closed. This will be in 2622. Now the IA. But Mr. FKR Ahmed, counsel for the applicant. You just saying that separate orders being passed. Keeping this said interlocutory application alive. To be brought to its logical conclusion in due course. Now, in this application, you write, Mr. FKR Ahmed for the applicant. And Mr. KK Das, learned APP for the state. Respondent number 1. Mr. AK Sharma, learned counsel for the respondent number 2. Has submitted that as he is not aware of the grant of bail, comma, is expresses his disinclination to accept notice on behalf of respondent number 2. Next para. By filing this interlocutory application, comma, the applicant, comma, who is the informant at whose FIR what is the case number? Whose FIR?
PRC 111-8.
No. It was it was on this over. Hajo PS case number 888 of 2000. Hojai. Oh, acha, Hojai, not Hajo. Hojai PS case number 888 of 2019. Under section 120 capital B, public 302, IPC read with section 25 within bracket numerical 1 dash capital A, bracket closed, public 27 within bracket numerical 1 dash capital A, bracket closed, of the Arms Act, comma, corresponding to PRC case number 1118 of 2021 was registered, has brought to the record of this court that allegedly by suppression of material facts relating to pendency of connected BA 2622 of 2023, comma, had moved this court and the coordinate bench of this court by an order dated uh, 1/12/2023, passed in BA 2648 of 2023, was obtained. Next para, it is noticed that BA 2622 of 2023 was filed on 13/10/2023. And since then till today, you said the application was pending before this court. Next para. Therefore, the registry is directed to make an inquiry as to whether the opposite party number 2 hearing had disclosed before this court about the pendency of BA 2622 of 2023 in the proceedings of in the bail application in respect of BA number 2648 of 2023. Full stop. If the registry does not find a reference to the pendency of this, the pendency of BA 2622 of 2023 in the bail application number 2648 of 2023, the registry shall put up a note to that effect. So as to enable this court to take cognizance of the suppression of facts, comma, if that be so, comma, and take and pass appropriate orders. Next para. The registry, as this, the registry shall not treat this matter to be tied up with this bench, and accordingly this matter can be listed before the bench assigned to take up bail matters. Next, at this stage, when internal inquiry is being made, issuance of notice on respondent number opposite part number 2 is for the time being, dispensed with. List immediately after the registry completes the makes an inquiry. Next paragraph. Notwithstanding that the connected BA 2622 of 2023 has been disposed of on withdrawal, for the purpose of inquiry and to bring the matter to its logical conclusion, this interlocutory application is kept alive till further orders of the court. List after list to last to the list after the internal inquiry is made by the registry. This will be the last thing. Okay.
One of the hearing, number 3 of the lawsuit daily list, madam. There was an interim order, madam, which was operative till today, madam.
53. Just tell the court master. This
interim order to be extended to the next.
They'll do it. Please tell the court master. Any other matter where interim orders are to be extended, please tell the court master. Orders will be passed. Yes, Ms. Devi.
3536. I have to file objection against condonation petition there. 4, 5 respondents expired. So let it come after vacation.
On many occasions, my lord, he begged time for filing objection, my lord, but till then he does not file any objection.
I got it
My lord,
ready,
my
but I have
urgency
to
is
get
this.
a signature from the.
My lord, my
No, but do it since you see 23. What adverse orders would be forthcoming in appeal? We don't know.
My lord, my urgency is this, my lord, I filed 1 IA for substitution with limitation. The number 3 IA is, my lord, regarding construction of toilet temporarily, my lord, and because we have no toilet to use, my lord, with the permission of my adjacent neighbor, my lord, we use the toilet. So unless our name has been substituted, so we cannot make any pair for seeking permission for constructing temporary toilet. So my lord, the matter is very serious.
I
my
did,
lord.
we'll give you time, Mr. Jain, but do it by third.
Yes, ma'am.
We are taking up the matter on fourth,
Yes, yes, my-
4th of January.
yes. my-
Uh,
That's why, my lord, I have serious prayer before your lordship, my lord.
Okay.
Without toilet, my lord, no
Item-
one can live, my lord.
Item 35, 36.
Yes. We made a prayer, my lord, with
It's okay.
undertaking, my lord. If we fail to succeed, we will
So let me file.
dismantle the toilet, my lord.
Oh, okay.
But without toilet, my lord, my nearby neighbor, my lord, they are not at liberty to give us permission
Now, how I can,
for so long.
my residence is separate, their residence is separate, how I can allow them to have toilet in my
In
lane,
presence of police,
in
my
my
lord.
premises?
We have no objection in presence of police,
How
in
the
presence of
police-
respondent, my lord.
No. She's saying that in the presence of police, she will make the construction.
Yes.
She doesn't say she will go to toilet in the presence of police. Correct? This is not her proposition.
Skip some portion of the sentence.
My
Huh?
lord, he has to appreciate
Say,
our.
skip some portion of the sentence.
No, we understand that. I told you, few moments back, I told you that I have a tendency to hear so much and try to understand so much. So that is a bad tendency, but I still do it. Item number
35.
35, 36. Ms. B. Devi and counsel for the applicant expresses some urgency in the matter as the applicants urgently want construction of a temporary toilet till the pendency of the connected appeal. Full stop. Mr. R.K. Jain and counsel for the opposite party prays for a short adjournment to file an objection in the matter. Full stop.
Regarding substitution matter,
My lord,
what substitution matter will be taken?
No, we can take up together because these are, you see, when it is of urgent nature, which is a toilet, pending substitution also we may permit to.
They are constructing, they are building on their land and there is.
oh, my lord,
No, we don't know, but once it is a question of the essential services of toilet and water, we may tend to bend some rules and then take the matter up. At least we'll take up the matter.
my lord, that is IRC number.
Objection.
2441.
No, whatever, I'm not saying that. This common order will be passed in item 35.
We
Mr.
filed this
Recording
petition,
the-
my lord, in the month of June, my lord.
No, that is okay. Please complete, allow me to complete my order. Otherwise, we will both sit
Sorry.
together till 6 o'clock here.
Sorry.
First stop. Therefore, objection if any by the opposite parties will be filed within 3/1/2024. In view of the urgency expressed, list the matter on 4/1/2024.
Much.
This will be covering two IAs.
Yes, my lord.
No, 2 or 3 IA. How many IAs this will cover?
First, IA 2427 is well under section 5 of the limitation act.
So just a moment. 2427. This order will be common in 2427. Then
2439 is for prayer for substitution.
2439,
Yes. Then 2441 is for.
2441.
prayer for seeking
Okay, and
permission for construction of.
yes, and
Toilet. And my lord, RSA 306.
no,
my lord,
RSA is something else. We will not touch the RSA right now.
Connected this, my lord.
Only these three.
See, my lord.
Orders are only 3.
Is, regarding, my lord, order 4105, then status quo order was passed, that has been.
No. I'm just asking you very simply, this order will be passed in which IAs? Just tell me those numbers. What is in the other things I don't want to know.
Yes, my lord, 2427, this section.
Okay, these three matters only. Huh?
And
3 matters only.
2439 is for substitution,
Okay,
2441 is for taking permission for construction of
okay.
toilet temporarily.
Only this matters. Yes. Yes. Any other prayer?
And he has been taking time for filing objection. Our objection has not
Oh,
been
we,
filed.
everybody who is associated with civil practice, we'll pray for an
Otherwise-
adjournment. That is why legislature had made order 17 rule 1. You have to invoke it. Correct.
Otherwise,
We will curtail what you call liberties of the lawyers if we stop adjournment.
you should appreciate our
So
inconvenience.
even after what you call that, what is that? Salem Advocates Bar Association, still we are finding out ways and means to adjourn the matters. Yes, any prayer?
My lord, I, 50, presenting the respondent original plaintiff. Stay order is operating against me. May I pray for fixing it on, just after Bihu vacation?
No, not after vacation, because we can't accommodate the board.
29th of the.
We will not say anything. We just, all these matters will be rolled over. You make a mention later on, because I'm not fixing a date. You see, it will be very difficult in a board of 60 cases where I'll pick and choose few cases and post a date. And in others will be rolled over. No, it will just be rolled over. You make a mention after the vacation. Correct. You ask someone to make a mention, we'll take it up, because it would not look nice to pass order in one matter and then in 10 matters we are not passing any orders.
The consent of the other
No,
party.
no, that be okay, but
Public.
there are difficulties, administrative difficulties. You have seen today what has happened. Questions are being put to our what you call efforts. You have seen that whatever happened. So we don't know, don't want to take any more risk. My what you call, my open mouth has created more problem for me than Sakar. I don't know. Huh?
Conversation is always good, my lord, and it is giving succor.
No, but you see today what has happened. It has led to application being filed that this thing be brought on record. It will curtail the. That's why you see this question. I'm asking to the bar time and again. If I stop speaking, what would happen to the bar? What would happen to junior lawyers who are striving to become an upcoming lawyer? Everybody would be afraid in entering the courtroom and then deliberating. I would become a terror instead of being a what do you call, judge. It's not expected of a judge to become a totalitarian. Although I have a tendency to become one, but
I don't think so.
Some joy will go out.
huh?
Some
I
joy
have
will
been
go
sitting,
out.
my lord, for the last 2 hours.
Some joy will go out.
Some joy will go out.
Whether the preposition is right or wrong, at least since I come from the bar, I think that I should hear. Well, maybe a good lawyer, a stout lawyer will give the best argument in the first go. And maybe the other lawyer who is not so well prepared, maybe he'll go serially and the best point he will take at the last item.
Yes, that happens, man.
So if I stop, then I don't know, but we'll have to rethink. It calls for a debate within our system. How much should we do? Because we become a matter of public debate. Once somebody puts a question, puts it on record that this has transpired in the courtroom, we become a subject of public debate. I don't know, we'll have to debate within ourselves what will be the appropriate way. And this deliberations have disturbed me. I don't think it's very easy to. Normally, I don't take home dead bodies. What happens in court remains here. I don't take it out. I don't keep dead bodies in my head. Something I don't think it will go very easily. I have a feeling it will not go very easily. Keeping dead bodies makes one prejudiced. That's the difficulty. If I am prejudiced for a particular issue, I won't be able to discharge my duties, what is expected by the bar. I don't know, let's see, there is always some upper